19.
Lord. Item 14. I pray 7 days time, certified copy I have applied, but I will get it within 2 days, my lord. But I pray 7 days.
On 9th of October 2023, at the request of Mr. S.C. Dust and Council appearing to the appellant. Meanwhile, the certified copy be obtained and submitted in the proceeding. Next.
Page 12, item 20-32.
Now, item number 21. Well, I pray, well, let this matter be taken up
Today, we may try, but today is, let us see. There.
Oh, bless. I will be waiting.
Okay.
Page 13, item 23-27. Page number 14, item 28-33.
Item 28, my lord. 28, in this case, I have already removed the defects last Thursday. It will be listed after further SR, my lord. Lordship may taken up any day after 11 September.
All right. Let this little matter be listed on 26. 7th of September 2023. Meanwhile, the fresh SR has to be done.
Obliged. Item 30, my lord.
Yes.
The trace retouple may be taken up.
Okay.
Content question has been filed. In order
All right, you just point. What kind of defect he has left already? What kind of defect he have removed?
Then it is not
10 rupees on clock number, 10 rupees clock. That has
Oh, that's for that SR is not required. This last line is SR is this one. That's the matter be listed on section 7. It has been stated that all the defects that are made with the registry.
on 24th I have paid.
remove one defect.
He has removed the defect.
On 24th I have paid my.
Oh, no. Okay. Office.
Yes.
30th may be taken up to.
Just to point out, I will take up.
Page 15, item 34-36. Page 16, item 37-41.
Lord, item 37 on your lordship's list, Lord, it's 2 writ appeals, Lord, it was fixed today. Lord, unfortunately, by order dated 20th of March, your lordship had directed the respondent to supply a copy of their reply. That's yet to be done. I don't want to burden your lordship's board, Lord, and take an adjournment.
Been to the respondent item 37.
For the appellant in this matter, he is respondent number 3. What had happened, of course, my lord, in the writ application, we had raised severe allegations because this arises out of a settlement arrived under 18.3 vis-a-vis the statutory obligation under a legislature which bars that. So that is the issue to be decided. So the Labour Commissioner had given findings in our favor, which was their part of the writ petition records. But we had raised severe allegations. The settlement which was arrived at, conciliation proceedings were not held properly. So I don't know, Mr. Das has pointed out, I was not the original counsel. So whatever
Reply.
Lie that let us.
well, he has filed some reply, but it seems he has not served copy.
That is he's also his complaint is appearing for them.
It's ALC Central, Lord, Assistant Labour Commissioner Central. I tried to verify, Lord, the name also is not reflected on the list.
Was item 37?
Is it a private council or the central government council?
Must be central government.
Must be central government, Lord. Before the Honorable Single Judge also, it was the central government council representing, Lord. And there's one more problem, Lord. The names of the council appearing for the party, there seems to be some error, Lord. I have already given the note to the courtmaster, Lord.
Yes.
Actually, I am for the appellant in the first appeal. I know it is coming for the respondent. Honorable Justice Roth had also pointed out.
No, I had also checked. You have written respondent. That is why the name is coming. I mean, wrong side. You said appellant. That is why I had checked.
Oh, my lord, I will get it correct.
I've given the check, Lord. It will be done.
Yes.
Because when you said I checked, I found it is due to
I
someone.
don't want to burden the lordship's board today, Lord. Some other day, Lord, and let them consult this copy.
Is the matter on 21st of September 2023. Let it come on 21st of September.
Well, may I pray 25th, then 26th, subject to your lordship's board, Lord?
Okay, 26th of September.
26th, I'm obliged.
Item 41, let's see. It's a part matter. Let me take a chance today. Let's
All right. Let us see.
anytime 12:30 or let's
Come at 12:30.
Pardon to mention your lordships.
Page 24, item
My
42
apologies.
and 43. Page 25, item 44 to 46. Page 26, item 47 to 48.
My lord, may I be pardoned to mention, my lord, item number 47, my lord. My lord, in this case, I am the respondent. 2 appeals were there, my lord, writ appeals. My lord, in this case, the respondent was granted with the shop under a valid license. And all on a sudden, appellant number 1 handed over the shop to another appellant, my lord, without following due procedure of law on the allegation of subletting. My lord, interim order is operating against me since 9/3/2022. My lord, therefore, I pray before your lordship, this matter may be taken up any other day, my lord, as pleases, at 2 p.m., my lord. Can I pray that, my lord? At 2 p.m., any other day.
25th of September. What is the good name, ma'am?
My lord, Soma Patnaik. Soma Patnaik for the
Yes.
respondent.
The request of Srini Patnaik, Permanent Council, appearing for the respondent. At 2 p.m. 25th
Yes,
of
my-
September.
Yes,
25th.
my lord. My lord, interim order to be continued, my lord.
Interim order is passed, we shall continue.
Page 27, item 49 to 50.
Grateful, my lord.
Page 28, item 51 to 54. Page number 29, item 55 to 60.
My lord, item 55, I tell let it taken up today, my lord.
Item number 57.
With the lordship's kind permission, beg to mention, my lords, item 56. This is that matter, my lords, where a false affidavit was filed by the Union of India saying that
Yes.
the office bearer was dead when the application for renewal was filed.
Whether they have filed the affidavit.
They filed a-
They filed the affidavit, and I have filed the affidavit along with the death certificate, and also the sister has come all the way from Jharsuguda. But this is totally total false, and
No, you're saying he has died and not died, and now you're saying you got the death certificate or died later?
that letter, my
Okay,
lords,
all right.
they say
Have you filed
that
it?
I have suppressed. Well, I have filed, immediately I filed. And
Mr. Rai, you come 3:30.
330, my lords.
Fixing the matter, time.
My lords.
3:30. You also inform Mr. Parikh through.
Definitely, my lords.
Yes, yes.
Because these are very serious matter, my lords. Filing false affidavit is itself is very
Item number 57. may I
much of
take
length, my lords.
Mr. Mudali, that item 37 which Mr. Subrat Mishra was mentioning, item 37, that copy of our counter of R3 not filed, they were under the impression of the central government council. It's actually you have filed. So if copy has not been served, you check up, okay?
My lord, I am there, my lord.
Okay, okay.
I am obliged for the lordship's intervention.
Lord, item number 57 may be taken up today.
When we comment at 3 p.m.
Page 30, item 61 to 63.
Item 61, my lord. I pray for taken up today, my lord.
What is the matter about?
Matter that they have not released the salary for the respondent. I am for the respondent.
But your case has been dismissed in the last single. This was urgency.
My lord, I am not for the, I am for the respondent number 8. They have not released my salary. Till I am not getting my salary. They are challenging the another matter for the rate of it.
Item 61.
61, my lord.
61, the appeal by the private individual.
Private individual, they have filed the appeal, the management. I am for the respondent, for I am working there.
It has not been filed. Anjana Sahu has the appellant. You take up here.
Anjana Sahu is another petitioner. They have terminated the Anjana Sahu by the appellant, but I am the respondent. I am working there till today. I am not getting my salary. That is the problem.
But you did not file any writ petition.
No, man, I have not. They have noticed to me.
How can I give the relief in an appeal by other party to relief to you if you have not filed the writ petition?
You want vacation of order of stay, there is no application.
I have filed the IA for renewal of salary because I am continuing in the post. They have not.
You file a separate writ petition in someone else's appeal on another subject matter. We cannot grant relief because the opposite party state has a role in that. They can oppose if prayer is made. So there is nothing in that your case. You have completely misdirected your this relief brought to some other forum. You go for a fresh writ petition. It is a fresh cause.
Page 31, item 63. Your Lordship, the content is coming tomorrow. The Lordship may take it up today.
All right, it will be taken up at 12.
12.
Page 31, item 64 to 68. Page 32, item 69 to 77.
68, sir. At item 68, looks at the part-head matter, government was directed to file.
This matter, Your Lordship, kindly recollect, this relates to imposition of penalty,
Yes, correct.
use of groundwater as well as surface water. No, I have prepared the affidavit, but when preparing, some metal facts were not there. So I pay some more time, 10 days time. The interim order is in favor of the.
But the interim order is there, my friend is agreeable to that.
That's all right. They're on 25th of September.
12th September.
12th September is a lot of matters are there. 25th is a comparative index matter. That will be on 25th of September.
But interim order.
Right.
You can serve the counter earlier.
Calculation is concerned, that's
23. Mr. S.P. Mishra, Senior Counsel.
Mr. Maharana.
Huh?
Mr. Maharana.
Suggested by Mr. L.K. Maharana.
L.K. Maharana.
Counsel is appealing for the petition. The model is first earlier still continue till the next state. In the meanwhile, so that they file any reply. I don't understand whether this groundwater comes.
No, not that one. Minors, their contention is that they are paying regularly the water charges, but why the penalty? To that respect only, Milo directed me to file that.
I have got the that everything is there.
It's already just file the affidavit.
File it within 10 days and serve a copy so that he can give any return.
76 minutes. Item 76. 76.
Yes.
Lord, it is a habeas corpus petition, madam. Minor gal, madam. You not see.
You are now well?
Madam?
You are suffering from some illness.
No.
But mention has been made that you are ill.
Last
week.
Yeah, that is why we are asking.
It will be taken up. It will be there around 12.
In fact, that page there are 7 WPCRL, no?
Right. Page 33, item 78 to 82. Page 34, item 83 and 84. Page 35, item 85. Page number 36, item 86 and 87.
87 matters.
My Lord, item number 86. It is a part-hard matter, and your Lordship said had the matter just day before yesterday. But today, what I find your Lordships are heavily occupied. So I pray my Lords to kindly fix up this matter tomorrow or day after tomorrow at any time, so that it will be hard and disposal of.
Day after day.
15th or 14th. 14th.
My Lord.
13th. It will come on 13th.
My Lord.
13th at 2. But it's not possible because a lot of holidays are.
Yes, my Lord.
13th September, as parted on that day at 2 p.m.
13th September. 2.
Item number 87. Item number 87 is the selection of assistant professor, my lords, of SC Medical College
And the day before yesterday, the matter was there, my lord, and my lord was that was maybe taken up, my lord, so today, my lord.
Be there around 12:30. We'll try to.
Bail application. But if the present petitioner's bail application was earlier rejected by my lord Justice B. Nursing Lord. But arrangement of the same affair, my lord, the first bail application in respect of another case was earlier rejected by Honorable Justice B. P. Rautre. So my matter was listed before Honorable Justice B. P. Rautre. But that court did not hear the matter and inclined to pass it before the assignment. Now the registry is saying that it will not be listed before the Honorable Justice B. Nursing because of the fact that as per the notification of this Honorable Court, that the first bail application which was dealt with by the Honorable Justice, that should be listed before that one. But
So then according to assignment, it will go.
since earlier rejected by Honorable Justice B. Nursing, that should be listed before that bench because Honorable Justice B. P. Rautre is not inclined to hear the matter because since earlier bail application has been rejected by Honorable Justice B. Nursing.
The judge doesn't have any choice anyway, just send to meet me.
I beg
Pardon,
your lord.
pardon to mention, my lord. Pardon to mention, my lord. My lord, the appellant challenges the order passed by the single judge and administratively the Rule 10 and Rule 32B of the Consumer Protection Rules and holding that she is eligible for that post, my lord. So matter may be taken up today, my lord. I am challenging that. Tomorrow, my lord. Tomorrow, my lord.
It is not a single bench matter?
No, my lord. Appeal. This is appeal, my lord.
Oh, you read appeal.
Read appeal, my lord.
Go tomorrow. Let us see. Tomorrow.
I beg your lordship's pardon to make a mention. My lords, I had filed a writ petition against the order passed by the Odisha Real Estate Appellate Tribunal, and the same was listed before the Honorable Single Judge Bench of Honorable Justice Vishwanath Rath, wherein the Honorable Court observed that it was not assigned. My apologies to hear the matter. And my lords, from the assignment also, it is not very clear that which honorable bench of this honorable court should hear it. So my lords may kindly assign it to the appropriate year. I'm filing the memo.
My lord, on face admission matter, the PL matter may taken up immediately. My lord, review application, my lord. Just review application.
From which order?
Which against the order of the division bank, the fact is that in a auction purchase, I had purchased the property. That it was the possession was given to the lady. Against that, I had filed a separate review petition, but my lord was pleased to direct to file a review petition. Accordingly, the review petition is being filed.
My lord, division bench.
Yes, my lord.
Dated?
That is a 2012 matter. In separate
Order was passed.
2012, my lord. I have filed separate review petitions, but in that
I
review
understand that the review you are filing in respect to which order?
Passed in 2012.
order dated, my lord. 2012, my lord, sorry.
2012, we are in
21/6/2020, we are 12, my lord.
and now we are in the 2023.
In another review petition, my lord has been pleased to direct to file a review petition instead of interfering there. So accordingly, the review petition is being filed, my lord.
No urgency.
My lord, read appeal number 948/23. It has been posted today for hearing, but no list, that is not in list today.
Let's check. Based on that. Huh? That based on that. Let's check. Please find your memo of this case number.
My lord.
I will this matter was done for yesterday, but this
That to be listed today.
No, I'm not. But similar matters will be posted to 14th of September. That's
So that will be checked because in your case, if there is an order that will come on that day only.
I may pardon my lord, this read filed by state. Pardon my lord,
Any objection?
contempt.
Must be a delay.
SPL.
My lord, pardon to item number 28, my lord. Again, already 2 times petitioner taken adjournment. Today also taken adjournment. That my lord.
When the matter 28?
28, my lord.
Without informing you?
Yes.
28 days,
Today, he added to 27 September.
he's mentioned 28.
28 saying did not take his consent.
Today, Mr. Bhokta, here,
Is it 21?
Only the small defect of some 12 rupees or something.
My lord, last chance, honorable court directed, it is a last chance not to adjourn anything.
No, he has removed the defect.
So then it can be listed early.
You just inform Mr. Bhokta to appear before us again. You just tell. Let us see.
Today I will take this matter.
That will, because in his absence also he cannot pass any order.
86.
Yes. Yes, otherwise it has been fixed on 21st of September. 22nd of September.
He's right, 18 it was.
75 years old. He is claiming for financial benefit after retirement.
Mr. Paul, I do one thing. I make another sentence that the matter will be taken up for disposal.
Yes.
All right, because they have removed the defect, you come prepared.
Yes, sir.
This item, matter will be taken up for disposal on merit. Okay.
Yes, sir. Pardon to mention, my lord.
Yes.
My lord, this writ petition is related to the Vitarcha Mahanayak Seba of Lord Jagannath Temple. My lord, the matter was listed before Justice Biswanath Ratha, and he recused from hearing the matter as he was the counsel for Jagannath Temple. My lord, the Vitarcha Mahanayak, the opposite party has been allowed to tie Chanchu Sadi, which is the appointment procedure for Vitarcha. And it is an Eka Seba, which means that one person can be appointed. By this order, I have this order means that my services will be terminated, and I was not given an opportunity of hearing. Lord, may fix
It's a list.
Yes, signed.
Lord, actually, they are trying to carry out the order.
This is a division bench matter.
It's a single bench matter.
So we are mentioning before us, you just take back it and go to the registered judicial and make the reference that I have asked you to appear before him. Okay?
My lord, it is actually a little urgent because on 5th.
That is why I am asking.
I'll do that.
Person will be listing on the matter, seeing at the assignment, or otherwise, if he finds any difficulty, it will be brought on the administrative side. Already just mentioned before him.
There's another matter. It's a review petition. I had mentioned it on 16th. Your lordships had directed me to go to the registered judicial. It has not been listed yet. It is out of a review petition, out of a surfacey matter of Justice Jaswant Singh and MS Sahu.
Already we'll do it. You just go today also. Refer that I have made. And if necessary, he should bring the matter before me. Tell him this.
Highly obliged.
Subject to your lordship's kind, my lord. I sincerely apologize, my lord. I could not able to connect when the matter was called for adjournment. But the fact remains is that your lordship's today list item number 12. On the last occasion, there were the defects. The defects has been complied, and all these things are uploaded. I have checked with the registry, and the registry said me that it has gone to version 3, where it has been uploaded. But unfortunately, today also it has come with the same defect, which has already I have been complied. Lord, grant some time. I will verify personally, with the registry to find out what are the defects. In fact, the
all right. We missed the matter on 14th of September 2023. The request of Mr. Mr. Manoranjan Das
last time.
So in the meanwhile, if any defect remains unattained, shall be corrected. If Mr. you will come again on 14th of September. In the meanwhile, you do it.
Very well, Milord. Very well. I am deeply obliged, Milord. I am apologized, Milord. I could not able to read.
Yes. May I call the list?
I am obliged, Milord.
Supplemental list, first addition item number 1.
May I please, your lords? In order to ease unemployment problem, the state cabinet have decided for empowerment of diploma civil engineers as junior engineers. Accordingly, chairman of the committee of chief engineers and engineering chief of the committee on behalf of the state government issued public notice in Delhi area newspaper
inviting application for diploma holders civil who have passed during the year 1994 to 2009 for their empanelment and inclusion of their names in the panel for appointment as junior engineer civil. And the applicant, after passing Industrial Training Institute in Draftsman Civil in the year 2003 in Government ITI Puri, has got admission directly into second year diploma in civil engineering as a lateral entry of diploma course in civil engineering. You will also kindly see Annexure 2 at Annexure 3 at page 17. The 17, my lord.
Yes.
I have requested to supply the appointment of 2 persons, those securing lower position and lower marks in the panel have got appointment. The engineers is informed that serial number 3, your lordship kindly see, appointment letter of Hindu Madhav Sarkar, Deepak Kumar Das, it cannot be provided as this office is not their appointing authority. However, percentage marks obtained by them in the diploma examination is as follows. Hindu Madhav Sarkar 73.44%, Deepak Kumar Das 73.35%. Both belong to scheduled caste community. The appellant also belong to scheduled caste community. The appellant secure higher percentage of marks.
What is the percentage?
Mine is 74.10. But the rank calculated 64% for which the appellant demand for appointment. The lordship kindly see my marks, Annexure 4, page 28. Out of total 3,000 marks, Annexure 4, page 28, my lord. So lordship got it. Out of total 3,000 marks, the petition appellant got 2,223 marks, 74.10 marks. I also obtained under RTI Act the marks secured by that Annexure 9, page 40, your lordship kindly see. Annexure 9, page 40. May I read, my lord?
No, it's already, I've seen this.
So, your lordship said. Your lordship kindly see their counter. Response number 2 and 3 before the honorable civil judge. That is page 33, my lord. Last paragraph. May I read, my lord?
Yes.
Page 33. In reply to the other affirmations made in this paragraph with regard to total marks and percentage marks secured by the applicant in the examination conducted by the council in the year 2008, it is most humbly submitted that the result sheet furnished by the council strikingly differs with that of the applicant claim. The applicant avers that he scored 74.10% marks in the final examination, having secured 2,223 out of total marks 3,000. But the result sheet furnished by the council indicates that the applicant secured 2,450 marks out of total marks 3,750, which is based at 64.39%. On the issue of variant version, a mark secured by the applicant, the state respondent has nothing to give in reply. Because of council submitted given the wrong answer of the wrong marks to the chief engineer in chief, therefore the petitioner could not give an appointment. Instead of adjudicating the matter on merit, the honorable civil judge disposed of the matter at Annexure 10, page 42, relying the judgment in WPC OIC 2645 of 2014, that is batch of cases, leading cases Santosh Kumar Mandal and others. In that case, my lord, some persons intended as a junior engineer, civil but not get appointment. Their position was lower in the merit list and subsequently government decided to make appointment. The honorable single judge dismissed the said writ application. The present writ appeal, my lord, is nothing to do with that cases, my lord. My sole contention is that because of wrong answer given, wrong marks sheet given by the council to the engineer in chief, the petitioner could not get appointed, even though in the same.
Can you say that is the wrong? It is their tabulation sheet.
My lord,
It is there table.
Your Lordship, kindly see the tables. That's it. Page 27, my lord.
That I have seen.
Page 27, my lord. Serial number 5 and 6, so far as Indu Malhotra Sarkar and Deepak Kumar Das are concerned. The secured 70.4, therefore they placed serial number 5 and 6. Mine is serial number 53. How could they get total 2,415 marks? They calculated out of total 306 minus.
Mr. Behera,
Your Lordship.
apparently the mark sheet shows he got the more than 74% mark.
Maybe, Your Lordship. I have one issue on maintainability. He is challenging the appointment of Indu Madhav Sarkar and Deepak Kumar Das. They have not been made parties.
I am not challenging, I am claiming appointments.
There are no vacancies left anymore. That has been recorded in the judgment of the learned single judge.
Doesn't see. Honorable single judge denied the another
that under the SC men category there are no vacancies available anymore.
Then you have to challenge their appointment.
My lord, I have obtained under RTA Act, my lord, they have refused to give appointment.
Maybe you have a very good case.
My
The
lord.
court cannot pass any order cancelling this appointment with other person. Suppose there was a 10 vacancy. I am giving an hypothetical illustration. 10 persons have been wrongly appointed. You are better merit position. You are not. So there is no other vacancy.
My lord, when the matter was listed before the honorable single judge, I came to give so to amend the matter, but the honorable single judge was denying the counsel for the state, appearing on the behalf of the state, my lord, disposal of the matter. After obtaining RTA Act, I came to know that the person who to securing work position and no marks, they got appointment.
You file an application here.
I will file your application.
Because unless they are hard, we cannot pass.
I'll
Absolutely right. If there is an additional vacancy available without disturbing their appointment, we will pass order. Because there is no vacancy.
Vacancies are available.
Not a single vacancy. is
No, Your Lordship. According to page 50, Your Lordship will see annexure 11. The judgment of the learned single judge in WPC OAC 2645/14.
Yes.
The Lordship sees page 59. Paragraph 15.
Well, civil cost vacancies are available. So far, other vacancies are concerned.
There you may not be the successful candidate because their marks may be much higher.
That is relative to selection 2014. Mine is selection 2008, my lord, 2010.
No.
But problem remains the same. The government must have vacancy to accommodate you.
Well, I as you lordship rightly pointed out, implicit that said 2% the rate of appeal, my lord.
And they are working for all these 10 years. You also take instruction whether any vacancy is available.
Your Lordship, at paragraph 15, it is clearly mentioned that there were 1869 requisitions made.
That judgment also challenged
1869 requisitions. 1612 posts have been filled out and 257 posts.
Mr. Behera, the statistics we all know. What happens? Someone leaves the job, someone gets promotion, consequential vacancy may be available there.
I'll find out.
We are here to sort out the matter without disturbing the persons who are already appointed and already there is 13 years they have served.
Your Lordship.
It doesn't look nice for a court to disturb their appointment. But at the same time, apparently you are satisfied there was some mistake committed at the time of calculating the marks. So you also are granting a time in the meanwhile, you just 14th September, we take up the matter.
I'll take it.
Mr. A. Behera and Council has submitted that there is no vacancy in the post of the diploma engineer.
Your Lordship.
women civil, man. Women civil.
Diploma engineer civil and all the posts have been appointed.
Your Lordship, may I just clarify vacancies prior to 31/3/2014.
Vacancies prior to 31/3/2014. Stop. According to him, since the petitioner did not challenge the person who have secured lesser marks but has been selected and appointed, this appeal and the petition or the consequential appeal might be maintainable. Stop. we grant leave to the appellant, make the proper application for imprisonment of the person who may be affected if the pleas of the appellant is accepted by this court. Meanwhile, Mr. Behra, ASC shall also take instruction whether any vacancy is available in the said post, vacancy earmarked for the SC category candidate in the said post. You come on it. Yes.
This matter was heard at length, my lords, on the last occasion. This is pertaining to the election of the Kayonza District Tractors Association, my lords. My lords, on the last occasion, lordships had directed us to take instructions whether it is acceptable to the parties for appointment of an independent election officer, which we would like to submit that we have no objection if an independent election officer is appointed by this court, my lords, who can conduct the election in a free and fair manner.
If I may be permitted, my lord, I'm filing a intervention petition, your lordship, in the court itself. I would like to bring certain facts to this to the knowledge of this court.
Only one point you have asked, whether if the independent responsible of public servants is appointed, do you have any objection or not?
Your lordship, my small submission herein is that the election procedure has commenced, your lordship, and it has been proceeded considerably. Given in the light of the judgment of the Supreme Court passed in 1952 AIR, the Punnuswamy judgment, this court shall not interfere right now, subject to
the election. In the Punnuswamy judgment says this election of the Assembly, Parliament, irreversible things. It is a society's election. Forget about all these things will not apply in this case.
My lords, I am appearing for the respondent virtually. My lords, I had no objections in if an independent body is appointed, but my lords, I have to bring certain facts before my lords. My lords, the voter list has been prepared. It has been finalized after taking objections and of all the members of the society, and the final voter list has been prepared. Secondly, my lords, all the candidates have filed a nomination. The nominations has also been finalized. Who are the candidates who are contesting the election? That has also been finalized. Now, the only thing remaining is the voting of the members is remaining. That is on September 24th. So, my lords, my only prayer is, if my lords are still appointing an independent body, let it continue after this entire procedure is completed. Let it only take in consideration the election and not to restart the process again.
How that can be? No. How that can happen that you are completing the elections and then you are opposing this proposition that you have made.
My lords, because now the issue is everything is done. Now, if my lords restart the entire process, the
if you want peace and functioning of the society, you must accept that the first steps will be taken by the court without any inhibition, because we will not observe anything, the wrong, right, anything. We'll just appoint an independent persons to look into the matter so that there is no grievance in the members.
My lords, the grievance of the members, regarding the grievance of the members, my lords, the outgoing secretary was the one who had prepared the voting list. It was just only finalized by the magistrate. Everything process has been carried out as per the bylaws, only because the elections were not being held. Therefore, my lords, the single judge was pleased to pass this order that only let the voter list be finalized by the ADM, because it was not being finalized by the outgoing general secretary. My lords, that was the limited thing that the...
No, just tell me, whether the outgoing general secretary directed and prepared the list during his valid tenure or after that?
No, my lords, after the tenure. After the tenure.
How can he do that?
That is the whole issue, my lords. That is the reason why we came before the single judge. Because what had
how after his valid tenure he can just issue the voter list, inviting objection, publish the final voter list, declares the date for this election?
My lords, that is the reason why the single judge passed the order that the ADM will take into look into that, because that is what the outgoing secretary was doing. He was not letting the elections being held. He was continuously creating problems there and problems and disturbances.
And that is taking all these matters we proposed on the last occasion, that we just appoint some responsible officer from the executives and they will hold the election within a very short.
I leave it to my lords. I have no problems in an independent.
So all the election nominations paper, everything will be cancelled and he will take the fresh course.
I leave it to my lords. I have no objections to that, my lords.
All right.
Lordship, I am also filing one intervention application. Lordship, the advisory board conducting election on the zone basis without any procedure that the election, Lordship. the zone basis, suppose this is the association, Lordship, Odisha High Court Bar Association. They are considered that the members who are belonging to eastern part of Odisha, they are as president. Who are the
This will be according to the bylaws of the secretary. You can advisory board change the bylaws.
Lordship, there is nothing in bylaw, Lordship, regarding election. So they monopoly advertise that and the election. Lordship, kindly see page 35 of our intervention application 5978, Lordship.
This by the same person. Subindra Kumar Jena?
No, Lordship, his person is Satpathy, Lordship, Shivnaran Satpathy, Lordship.
Where have you filed this intervention application?
Lordship, kindly see page 35. The advertisement. Lordship, this is first intervention application. Okay, Lordship, on that I annex same thing.
What is the intervention application? Oh, this is one.
Lordship, two intervention application is there, Lordship.
But the cover is this
5931 and 5978, Lordship.
Yes, Lordship 35.
Page 35, Lordship. Lordship in 5978, Lordship.
Who intervention?
Lordship.
You file who intervention?
Lordship.
Okay.
Lordship, the petitioner is interested for contesting election for the post of secretary, Lordship. But that the advertisement is president from the one from the Andapur subdivision, vice president, one from Andapur and Keonjhar subdivision. General secretary is Keonjhar zone, Lordship. They are conducting election on the zone basis, Lordship. They are segregated in 7 parts, Lordship, and fixed for election in due to their personal interest for winning one single candidate, Lordship.
No, this voting sector will be zone based, but they cannot restrict the president or secretary on the basis of zone. How that can happen?
Lordship,
who is appealing for the petitioner here?
Mr. Mahapatra.
Yes, my lord.
Lordship,
The independent election officer will take care of everything. Follow the election process as respect the bylaws. Then elections can be conducted. But like this, several intervention applications come, some will oppose, some will allow direct that they should be conducted. To avoid all these complications if elections are conducted, they will take care of everything, my lords.
Lordship, we have no objection to appoint any independent election.
Who was objecting?
He's having discussion somewhere. Where is he? Now you don't want to press your intervention. Then come here. 1 second, okay. Intervention. Already filed one yesterday.
Your Lordship, currently, what my major objection to the said observation is that
the process is started.
So the first point is the process has started.
But what is your authority to start the process? When your term was over, within the term you did not hold the election, and after the time the bylaws doesn't provide anything how the election will be conducted.
I have filed my nomination in the fresh election, Your Lordship. My name is
questioning the very election, validity of the very election process.
But Your Lordship, once it has started, my attention subject to your.
These are not the election matter in the case you are mentioning. These are the public, the election by the for purpose of representation to the legislative assembly and other local bodies election. That will not apply.
May I?
It is a democratic society.
May I intervene here? My lord, may kindly turn to Annexure 6 at page 58. And there is a direction by another coordinate bench of this honorable court. No, by the honorable single judge. Lords, may kindly see. It starts from page 58. Order starts from page 63. relevant portion
Come to this, yes.
66.
Yes.
Though the Land Council for the state raised objection against the maintainability of this writ petition, but in view of the limited nature of grievance of the petitioner who is a member of the association, the opposite party number 4, additional district magistrate Keonjhar shall do well to issue necessary direction to the advisory board of the Keonjhar District Crop Owners Association, that is opposite party number 7, in terms of annexures 5 and 6 for initiating necessary action for election of the governing body of the Keonjhar District Crop Owners Association office within a stipulated date. In compliance of this order, next page, my lord, we can see annexure 7.
Yes.
This is the election schedule. So election process started. Now I will place section 28B of the Odisha Cooperative Society Act. Because this is
a society, this is an association, this is cooperative society, this is not a cooperative society.
Cooperative society.
It's registered under the cooperative society. It's a society.
It's an
association.
Society. There's everything will be guided by the bylaws.
My lords, after that judgment of order, which my learned additional government advocate is pointing out, after that, my lords, there is an order of 1/8/2023 of this honorable court. My lords, that is annexure number 5, starting at page 40.
Yes.
My lords, last order I had
not been challenged. This order has attained finality.
My lords, that has been clarified. The role of the advisory
written finality.
Which order?
Annexure 6.
That is right, my lords. After that, my lords, annexure 5, my lords, may see, that is at page 40, relevant part is page 55. They have clarified the role of the advisory body. That is at para 18, my lords. Para 55, lordship may have for a moment. Page 55, para 18. They have explained, the court has explained in detail the role of the advisory. Lordships had gone into all these details on the last occasions. My lords, if I may be permitted to place those para 18 again, my lords, for my lordship's reference and my learned AG's convenience,
yes,
I will refer to that para 18 at page 55. That is referring to the power of the advisory board. The said clause of the memorandum society under the act does not show that election of the KDTOA to be conducted by the advisory board. It shows that the advisory board is authorized to exercise an extraordinary power to deal with emergency subject to reference of the president. It seems that no extraordinary emergent situation arises in the present case for the advisory body to take over the office of KDTOA. However, the ADM of the issued order dated 25/2022 has directed the advisory board of the KDTOA to take over the office and initiate necessary action for election of the next governing body of the KDTOA by 30/9/2022. So also in the interim minutes of the meeting dated 23/2022, held in the office chamber of the ADM, it was decided to direct the members of the general body to enable the advisory board to take over the office of KDTOA to process and complete the election by 30/9/2022. In such way, the matter the petitioner is allowed the interim letter dated 25/2022 issued by the ADM and the interim minutes of the meeting dated 23/2022 in the office chamber of the ADM are hereby quashed. Additionally, it has been brought to the notice of this court that the office bearers have already started the process for conducting elections of the KDTOA in the month of September 2023. The district administration Keonjhar is at liberty to take any such steps as permissible under law in case any law and order situation arises in connection with such election. It is made clear that steps taken for the election of KDTOA at the earliest possible so as to avoid any kind of unpleasant atmosphere in democracy of the association. So there is an apparent inconsistency, my lords, between that order and the order passed subsequently 1/2022 and the interim order. So therefore, to resolve that, lordships had proposed on the last occasion to appoint an independent election officer, which is bereft of the influence of the ADM or any other political functionary. That's all, my lords. Therefore, my lords may appoint an independent election officer. My lords may suggest that a retired judicial officer, if he will officiate as an election officer, it would be a fair and free and fair elections that will cost will be borne by the association, my lords. That would be an appropriate.
You are not agreeable to that.
Lordship, my only point is that once it is considerably publicized that the election will take place on 24th September, Lordship, right now resetting the clock back, given the fact that
we can take the clock back.
Lordship, again reinitiating the process which has
unsettled. Will unsettle the entire process.
But the Lordship,
ADM has no right to go and hold election against the prescriptions and bylaws. And if there is no prescription, it is the only authority of the general body meeting to decide what the next course will be taken by the society. It is not the someone who will decide for the members. governing body is the subordinate for the society. So all this process is apparently invalid process.
My lords, the
If you
situation.
agree, I think the society's future will be protected. That is the purpose that we proposed. We have no business to propose that. If you agree on that, that we can do. So that you must sail over the present crisis. Have a elected body, run the society properly. And certain things are pointed out. Those are not permissible. The president must be from that zone. Because of it is a two-tier election system. And one part is the direct election, other part the members will decide accordingly. All the members are deciding the governing body member. And governing body is the general body of the society. So unless the proper voter list is published, how it will be determined that they are the voters and they are the members, they are continuing in the society. They have paid their subscriptions, they have paid the area fees and what is liable to be paid by them. It is only because of the final voter list or the members list is published that only someone can know it. So it decides amongst ourselves. Otherwise, we are just add to this crisis by the judicial order.
I'll take instructions. Your
They take instruction.
Meanwhile, Your Lordship, at least a copy of the writ appeal may be provided to me.
Intervention.
Have you filed your intervention application?
Yes, sir. Just in the court itself.
Is
Yes,
this the
sir.
filing?
How can you supply your copy then?
I have a soft copy, Your Lordship. I'll supply it to my learned senior.
No, give it today. They will take up the matter on day after tomorrow.
Saturday.
Saturday is the court working day.
My lords, may I request not on Saturday, maybe Monday, my lords?
Saturday will be convenient.
My lords, Saturday would be a bit difficult for me. That is why I'm requesting for Monday.
Already on Monday. But we're passing an interim order. No further progress has been made in terms of the election notice.
Yeah, definitely.
নমস্কার সবিত্র কুমার জানা ক্রেডিটর जो केस দিলাম ওটা উদ্যোগ দাও
Yes, Your Lordship. I'll file it before the registry.
All right, file it before the registry because we are taking the matter after some time also in Monday next. So, let me go to the registry. So the Mr. Mahapatra for the appellant, Mr. P.K. Mududi, AGA, you are appearing for whom?
My lords, I'm appearing for respondent number 6, Anirudh Sangan area, my lords.
No.
Lordship, I am for interview.
1 to 5. And Mr. Anirudh Sangaraniya, counsel appears for the
Respondent 6, my lords.
respondent is 6. So Mr. Odhirath Mohanty, one intervention application. You have the two intervention applications.
Two are different
Two
grounds.
intervention application has been filed. So, like those intervention application at this case record. So, you have filed one?
Yes, Lord. I'll be filing it in the registry, Your Lord.
Already filed, okay. File it. I think you better come together, decide, because these people will not understand the legal implication. They're highly charged with the emotion. And tell them that whatever way election will be going according to the bylaws. And if there is any subsilently in the bylaws, court will fill up. So that a fair and wide accepted election is organized. No, so this way you go. And he is raising the technical objections that will delay it legally. Don't worry for that. It will come with a consensus that will be much better. All right.
I'm very grateful, my lords.
Much obliged.
My lord, it's a PL regarding vacancies of 5 members in the Odisha State Food Commission.
Lord,
A
last date,
chairperson was appointed, but all the 5 posts are lying vacant.
last date I had submitted with your lordship that we have already issued advertisement, applications are received. And it is in the process. Your lordship may give me 2 weeks time. I will come back with current status.
Complete the constitution of the body, complete it. With the difficulty, giving you 30 days time, complete the constitution.
Yes, but the last date interview was there. But what happened, I will just.
Whatever happened, you are to constitute. We are giving you 30 days time. On the basis of the result, you complete the constitution.
And there is a process the government has to, it will take, your lordship may grant me 10 days time, last opportunity, I will give the status.
Let the matter be listed on 14th of September 2023 at the request of Mr. D.K. Mohanty, Learned Additional Government Advocate, Mr. Praveer Kumar Das, the petitioner in person, has appeared in person. Petitioner, Praveer Kumar Das, the petitioner has appeared in person. So, with the process of selection of the members of the Odisha Food Security Commission.
Odisha State Food Commission.
Food Commission. Was that the last slide? The petitioner has appeared in person. So, Mr. D.K. Mohanty, at the request of Mr. D.K. Mohanty, now Mr. Mohanty has stated that the selection process is on the fag end of the fag end. Therefore, if some more time is granted, the process can be completed.
Did you say that the chairman has been appointed?
Yes, chairman is already appointed, Abanikanta Sahu. Abanikanta Sahu is the chairman. Last date I had given the notification also.
The chairman has been appointed. Chairman of the Odisha
Only members.
The State Food Commission has been appointed. So for the constitution is concerned, it will only concern the members. All right.
14th September. 14th September. Oh, last. Item 4.
Item 4, last occasion, 28th, my lords, directed me to file an affidavit on 2 aspects. Yesterday the officer came with incomplete instruction. That's why I have requested him to supply the detailed information as to what.
The last order that no further recommendation will be made.
I want to implement my lord's order.
And it's all right, but
because now here the prayer is that why the order passed in the year 2004 has not been implemented. That is the sole issue.
Okay.
The person is a newcomer, he is not able to get all those old records. And he has to obtain instructions about the status of the civil suit which is pending. Whether it is disposed of or pending.
That is why he asked that what happened after that.
Married in page 43, my lord, in the officer order, revenue officer order, my lord, 133, 92, I think dealt in the.
That's all right, we got his point because he wants some more time only.
Marriage is knowingly taking time to time, my lord.
No.
How will it benefit?
We also know Mr. Mukuli.
So it is involved to sell the government lands in favor of the public due to the land was not yet
If you adjourn the matter, they will sell lands in the meanwhile.
Due to the PL, he has not stopped this process.
If he sells any land during pendency, you bring to an office.
Well, this Tahsildar is settling over the land.
Yes, ma'am.
But it is the government land. If his settlement is made, premium has to be paid according to the government rate only. Already,
not settling matter. Due to the it is not corrected in favor of the government, until today, the illegal record has.
Has come.
No neutral to question is very well. He was charge discharge into charges and Tahsildar. This is only
Wait a minute, he says this person has joined in 3 months.
last 2 years.
2022 he has joined.
No, the settlement was provided according to the Consolidation Act, I believe, when this.
Odisha land accounts.
They are on that land. This, because with the ceiling holder, I don't understand. What is the meaning of ceiling holder? The persons whose land has been declared surplus.
Ceiling surplus.
He was the erstwhile king.
Say that, huh?
He was the erstwhile king.
I understand now the ceiling survey.
The abolition of estate.
Survey has been operated and some land was found to be surplus beyond the limit of the ceiling.
Yesterday, what he could explain me, that challenging the self-same order passed by the revenue officer, he preferred appeal before the ADM. Now, ADM has passed certain orders, but he could not be able to produce all those details of which order was challenged.
Now ADM one order was passed due to declare the published trust. The same was declared by the tribunal from ADM, and same was challenged before this Honorable Court, Honorable High Court. Honorable High Court dismissed this same and allowed this same set aside in the order directed that is not private public trust. The same was challenged in Supreme Court. Supreme Court was dismissed. Thereafter, this order passed. In again Ola division, the Tribunal Board of Tribunals revised this sealing cases, my lord. In sealing cases, the Ola division has directed set aside all the sealing cases who are illegally settled in favor of the sealing holders, my lords, and his sealing holder and his sons, my lords. Then directed to dispose of the sealing cases, and thereafter the order has passed, my lord. Same was also challenged this Honorable Court. Honorable Court also dismissed the same, and thereafter Supreme Court. Supreme Court also dismissed the same. When this order of the Board of Revenue is confirmed, I have annexed in Annexure 2, my lord. That is Ola Revision Case 107 of 87. Only to not correcting the record of rights, number of petition was filed. The public trust is decided by this Honorable Court, Honorable, as well as Honorable Supreme Court, my lord. Therefore, this land was vested to the government, my lord.
He's saying in spite of that order becoming final, you are not correcting the record of rights of the government. Which is the advantage in selling those lands.
Yes, for implementation of the order dated 5/3/2004. Now, your lordship can see Annexure 2.
Yes.
This revision case was filed in the year 1987.
The 2004 order, he's saying it has not been set aside, but you are not giving effect to
This
that order.
revision case under Annexure 2 was filed in the year 1987. Well, after that, this order of the revenue officer came in the year 2004.
Yes.
And what was challenged in the revision is the order dated 27/1/1984.
Yes.
I am
challenging this order.
But our order, last order, 28th August, is very clear.
Yes, that is clear.
Instead about the 2004 order.
Yes, 2000. Well, he came with the instruction that order of the sealing of the revenue officer was challenged by somebody, but because incomplete records were there, was challenged before the ADM in a revision.
That was before the 2004 order.
No.
1993, 2004, isn't it before that?
No, after this, the record which he came yesterday, that was passed after this, after 2004.
You have a copy of that order.
Base number is in the year 2013, the order has been passed by the ADM. 10/5/2013, the order has been passed by the ADM.
What is that order?
No, that order copy he don't have. That's why I have requested him to bring all those case records of
Are you aware of that order in 2020?
What order has it?
No, he doesn't have a copy. Are you aware of any order?
I have not understood. What is the challenge?
The order of 2004.
Yes.
Right, the 5th March 2004 order, which you are seeking into implementation, we have also directed why it has not been implemented so far. It says that that order was challenged in a revision before the additional district magistrate, right, when the additional district collector, and there was some order has been passed by interfering with that order. But he is not possession of that copy of that order.
I have no knowledge about this one, but this same order was challenged before this honorable.
Already we can see what order, because the revisional authority has the natural jurisdiction. Let us see what order has been passed. When you can produce that order?
Look, so then 10 days time, he has to also obtain the status of the civil suit.
No, civil suit has been here made on the last occasion. Civil suit has been disposed of.
Same was decided in this their order matter. Just one matter.
So civil suit has been disposed of. There is no apparent impediment in recording the changing the entries.
Yes, ma'am.
In Jamabandi Khata.
Impediment will be if the order is, if any order is passed by the appellate authority. He is referring to the order dated 10/5/2013 passed by the additional district magistrate Kendrapada. That is in OLR revision case number 1 of 2007.
That he says the dismissal order. You check up.
That's why, because he was not having the entire order sheet as well as the case record.
Who is the new Tahsildar has taken charge?
October 2020, but he is not aware about all these things.
So let him appear with all the records on the next date.
And I was also inquiring from him, there are how many staffs? Only one staff.
The staff is very,
No additional Tahsildar is also there.
one additional staff is there.
Post vacant actually.
Mr. Rao, you have better date chart. You have made.
I filed a detailed debt chart about the deepest facts, ma'am.
Date chart.
11
Facts of 2 writ petitions, you have not given why it was filed, when it was filed. Just check your date chart. You have only said that it was disposed of. So make it more clear.
It has been stated by Mr. Muduli. It is in the affidavit in terms of the order dated 28/8/2023. Some new facts have been brought to his notice, which according to him very relevant in adjudicating the present dispute. So, Mr. Muduli, Mr. Muduli has intended to file a detailed affidavit covering those new facts, including any order passed by the superior authority from the order dated 5/3/2004, passed in sitting case number 47 of 1974. We also grant liberty to Mr. Bindraban Raut, and counsel is appearing for the petitioner to file a better list of events.
Item number 5.
Put upon when?
11th September.
May it please your lordship.
Oh, this we direct the Tahsildar. You appear on the next date with all relevant records under his custody. Yes.
May it please your lordship. My lord, here the petitioners challenge the violation of subclause 3 of clause 3A of the advertisement, my lord. Your lordship may kindly see the advertisement. And
Why this matter is before the division bench?
As the virus is challenged, my lord, it should go to the single bench.
Wow. Virus of what?
The notification, advertisement for recruitment of my lord, multi-purpose health worker.
For the first time in my life, I am hearing this kind of a statement. The virus of an advertisement is being challenged.
Because
Why do you challenge the rule?
I have not challenged the rule, my lord.
So how it can come to the division
Yes, my
bench?
lord, that's true. I will amend the writ application.
Unless you challenge the rule, you cannot
Wrongly, I have
challenge
not.
the virus
Yes.
of the advertisement. Already to come on 21st of
Yes,
September.
my lord.
But your prayer is that the provisions of the rule should be followed, act should be followed.
That is why there is no challenge.
Yes, I have not challenged.
It is not
Wrongly.
controversy. You are praising for the.
My lord, I will amend, my lord. Obliged.
At the request of Mr. K. K. Rao and counsel preparing for the petition, let the matter be listed on 25th of September 2023.
Well, in fact, he has challenged that is, madam.
In the meanwhile,
The challenge that rule annexed to with the rule. He has challenged that.
No, naming is defective.
He has challenged that rule.
Yes.
So, but what is the meanwhile, we must make in the repetition, that is not understood.
In respect to the prayers is
Item 6, obliged.
Lordship, senior is suffering from fever. Kindly post it to the next week.
Next week is not possible. Item 6.
Yeah.
What is the subject matter? You are not aware.
Sorry.
It was there for the central government.
Lordship.
We are fixing it on 25th of September.
Obliged.
The request of your good name,
Shashank Sekhar Paik, right?
Mr. Shashank Shekhar Paikal and counsel appearing on instruction of Mr. D.K. Roxwell and counsel appearing for the petitioner. Will the matter be listed on 25th of September 2023. Mr. Mohanty, you are appearing. Item 6.
We have not been served with any copy of this. That is.
Union of India.
Lordship, the copy is with me. I will solve it.
Defect number 6 is there. You serve a copy.
I will
Mr. D.K. Mohanty, Lani Additional Government Advocate, appears for the opposite party number 3, 4, 5, 6, 5, 7, 8, and 8. Mr. Mohanty has stated that no copy of the writ petition has been served on him. Already just, we are giving 3 days time. By 3 days you file the copy, huh?
I will file the copy.
Such copy shall be filed within 3 working days from today. He is not aware of the file, so his tenure is not.
No, I just wanted to know against which department this case is.
That tell me, I will tell you.
No, sir, I am asking. Yes.
He is not aware about the file, otherwise the public interest litigation. You are appearing for.
Chief Secretary, Home.
It relates to Home Department.
DGP.
All the Home Department.
Yeah.
Chief Secretary, Secretary Home, Director General Police, Superintendent of Police, Economic and Offences, this is relating to the cheat fund. And that's all. Others are all the central government of the registered.
I'll take notice.
Let him supply within 3 days, he will supply.
Yes.
Obvious, madam.
Item number 7.
Please, Lordship. My lord,
this matter was taken up on 29 and urgent to today to obtain instruction and to file a short affidavit today. Filing the short affidavit.
Have you supplied copy?
Yes,
just now I received it.
The relevant paragraph starts from paragraph 2 to 6 minutes.
Two to 6.
Paragraph 4 is and he is refused.
Have you gone through this?
And just now I gone through this.
Have you read it? Or you need time?
Lord,
because you do not find any irregularity.
My Lord, there is a, if a lordship's
Because
permitted.
they have given the entire things what they are doing.
My Lord,
First, one person was selected, appointment letter was issued. He later on expressed his inability, created a new situation. Therefore, they are thinking why the persons are not participating. They find because of the consolidated pay,
low,
they want to enhance it.
Man, with lordship's permission, my Lord, if a lordship's kindly, with lordship's permission, if a lordship's kindly see,
yes,
my Lord, Annexure 1, page 35, my Lord. Please kindly see page 35, paragraph 8, my Lord, last paragraph, my Lord. Where a vacancy in office of director occurs.
We have already reflected in our last order.
My Lord, your lordship says passed, is reflected that portion in your lordship's order, my Lord. So, but there is no provision regarding the extension of the service period in the bylaw. There is no provision, my Lord.
It appears that he has been set up by somebody.
No. The present petitioner.
Paragraph 5 of
That is why I was asking if he has any eligible candidates in mind. I was asking you could appoint that person.
My learned senior counsel is saying that.
Just read paragraph 5 of the affidavit. Don't go here and there. Is there this submission before this court?
It is submitted that as per clause 11, subclause 8 of the bylaw, the executive committee of the opposite party number 1 center will recommend a panel of 3 names from among the senior most professor fulfilling the eligibility criteria to the governing body for posting the in charge. Director till the regular director is appointed by the selection committee. Relevant to mention here, sorry, my Lord, to mention here that clause 7 of the bylaw speaks about the formation of the executive committee consisting of 8 members of 3 different departments of the government. In view of letter dated 29/6.
The latter part you are not concerned. You are concerned with this appointing from the present 3 senior most professor. One should be the director. That was your grievance.
My Lord, if a lordship is permitted, the executive committee, the formation of executive committee. If a lordship,
That they are saying 8 members are necessary from 3 different departments. That they have not been able to do on short notice.
No, my Lord, that executive committee, my Lord, the executive committee, presiding officer, page 27, my lord, in my writ application. Paragraph 7, my lord, the executive committee. The executive committee shall remain responsible for proper implementation of all policy decision in the governing body, supervise the affairs of institute, and issue direction to the director as deemed proper to attain the overall objective of the institute. Composition of executive committee. Executive committee shall consist.
It's all right. They have admitted that.
But here, my lord,
yes,
my lord, here, my lord, when the present opposite party number 3 is not eligible to hold the post, violating the bylaw of the institute, my lord. So he is not. So on that point, my lord, he is not entitled to hold the office as per the issue of writ in nature of co-warrant as decided by this on.
Co-warrant will not lie. You have already decided because he is not holding any regular post.
My lord, he is.
Sorry, this is a prerequisite for issuing the co-warrant. He is holding a regular post. Now is only mere in charge. No writ of co-warrant will lie.
My lord, in charge means if a lordship just I am for.
Yes, 2015. In charge to day-to-day function.
My lord,
and that you have one point that is they have answered in the this paragraph 5.
My lord, if a lordship say.
And Mr. Naik, you had no grievance when he was appointed in 2015. Did you have any grievance? Only in charge you have a grievance. When he was validly appointed, you had no grievance.
My lord, I have not challenged the.
Exactly.
My lord, I have not challenged the appointment in the year 2015, my lord. But when the amendment will come regarding the bylaw in the year 2021, then the present opposite party number 3 is not entitled to hold the office because he has already aged about 65 years, my lord. Now he is extending by the government, my lord. Extending by the government, my lord. My humble submission before your lordships, my lord. As per the
ଏଇଟା ମୁଁ କହୁଥିଲି ଗୋଟେ ଜେରକ୍ସ ଦବା ପାଇଁ ମାନେ କାଲି ଅର୍ଡର ପଠେଇଲା ବେଳେ.
If your lordships permitted me, I'll take time, my lord. I will.
There is no question. We are passing an order. You just wait, and thereafter you have any submission to make, you make it.
No, my lord.
Yes. Mr. Naik, you do not study, you do not know these things because what will ultimately you will get in this writ petition? First, you have already decided that co-warrant will not rely because that issue has become stale by flux of time. He is merely in charge. Whether you will allow him to continue or not, that is the final issue. And that is also you are interested in, that he should not continue. He was holding the position illegally according to you because they have violated this 11, rule 11 of the bylaws. That is your full grievance now. So you are addressing that grievance. Wow, will improve your case. I don't understand. This is a public interest litigation. And Mr. Muduli, this we are giving you the 7 days time. You just comply this your own suggestion that you recommend a panel of 3 names for the in-charge director and remove this gentleman because it is an expressive violation of the rule. That what arrangement you have made. You are supposed to make from those of the serving professors in the same institute.
No, why we could not make that also? We have stated in paragraph.
You have taken no initiative because it is your duty to form the executive committee.
2 months have elapsed.
It cannot be an excuse. I will not say lame excuse. It cannot be an excuse also. I have not these because all those of the government officers from 3 departments will come. A 5 minutes time is required to just nominate some persons. Mr. Muduli, you are the officer representing also the interest of the people.
No, your lordship, executive committee will nominate 3. They will submit the proposal for the governing body.
There is no executive committee to be functional now. Take the blame on your shoulder that there is no executive committee, which is an imperative of these rules. For that, nobody can in this world can be blamed except you. So first within 2-3 days you form the executive committee and within 7 days out of it made the recommendation And appoint one as the in charge director.
That will be appointed by the governing body, not by the.
And that is why executive committee has to recommend first.
If the process starts, it will be done. You have.
So within 7 days, the executive committee will make the recommendation. And for the final, for the selection of the new director, you continue the process. And they cannot have any say over that issue because the institute has to run according to the bylaws.
Amendment also that you can do.
The Mr. S.K. Naik.
SSK.
SSK Naik. What is the SSK?
My full name is Susri Sunil Kantana.
Right. SSK Naik and counsel appearing for the petitioner. And also Mr. P.K. Muduli, learned additional government advocate, appearing for the opposite party number 2 in particular. Opposite party number 2 has filed the affidavit in terms of an order dated 29/8/2023. Stating that in terms of the amended provision of the bylaws published in the Gazette on 39/2021 for the opposite party number 1 institute, in terms of the recommendation of the selection committee, one Professor Dr. Deepak Kumar Mishra was offered appointment for the post of director, but he has expressed his inability. Stop. Since the institute requires someone to hold the post of the director as in charge, Dr. Lalatendu Sharangi, opposite party number 3, was given the said charge by the notification dated 5/9/2022. For a period of 6 months with effect from 21/9/2022, or till the regular director is appointed, whichever is earlier. Stop. The said appointment is still continuing. No, sorry. This other party don't write the by notification such and such not given this phase such and such. It may also be noted that opposite party number 3 was earlier appointed as the regular director by the notification dated 5/9/2022. He was the regular director at one point.
That is page 53, annexure 2.
Regular director, sorry, by notification dated, it is the date is 2020, 13/5/2015, not
yes.
Date is correct. Against the vacancy that was created for there is vacancy created for end of the term of the opposite party number 3. A process was started to appoint a regular director. So as stated by the said process, Dr. Mishra was recommended for the appointment, but he did not join finally. So there's a stopgap arrangement. The opposite parties number 1 and 2 engaged opposite party number 3 to continue as the director in charge of the opposite party number 1 institute. By means of this public interest litigation, his continuous as the director in charge has been challenged on the basis of the rule 11, no?
8 mile. Rule 11, sub rule 8 mile.
Rule 11, we make it 8. Which deals with appointment of director.
Director relates to 11, clause 11.
Rule, clause 11 deals with the not rule. Clause 11 deals with this, don't 8 thing. Subclause 8 deals with the temporary vacancy that arises deals with the temporary vacancy. So, for purpose of reference, the same subclause is reproduced here under. Where a vacancy in the office of the director occurs, and it cannot be conveniently and expeditiously filled in accordance with the provisions of bylaw, the executive committee will recommend a panel of 3 names from amongst the senior-most professor fulfilling the eligibility criteria to the governing body for posting as IC director till the regular director is appointed by the selection committee. Stop. The petitioner has categorically objected the appointment of the opposite party number 3 as the IC director, as it is completely in contrast to the subclause 8. Stop. As reproduced. By the affidavit that has been filed by the opposite party number 2 on 31/8 today, from the affidavit, it appears that there is no executive committee in terms of the bylaws. So, for better reference, we reproduce the paragraph 5 of the said affidavit. Here under colon 5, that it is submitted that as per clause 11(8) of the bylaw, the executive committee of opposite party number 1, the Hypen Center, will recommend a panel of 3 names from amongst the senior-most professors fulfilling the eligibility criteria, to the governing body for posting of IC director till the regular director is appointed by the selection committee. Stop. Relevant to mention here that clause 7 of the bylaw speaks about the formation of executive committee consisting of 8 members of 3 different departments of the government. In view of the letter dated 29/6/2023, Dr. Deepak Kumar Mishra expressing his unwillingness to join the post of director And since convening of the executive committee meeting of the opposite party number 1 center at short notice involving 3 different departments was not possible by the conveners, keeping you in view of the larger public interest and to avoid any type of disruption for the day-to-day functioning of the opposite party number 1 day center, since Dr. Lolitendra Sarangi, the previous director who is having experience in the day-to-day functioning of the opposite party number 1 center, a decision was taken to allow Dr. Lolitendra Sarangi to continue as the director of the opposite party number 1 center as an interim arrangement, as an interim measure pending joining of a new director. We are We are constrained to observe the said shortcut step as taken is completely in violation of the clause 11.8 of the bylaw. Just one line, the no executive committee, that party just put out. In view of the above, we direct the opposite party number 1 and 2 to convene a meeting of the executive committee within a period of 5 days from today and recommend a professor, after considering the panel, after considering the eligibility criteria, recommend a panel of 3 members from amongst the senior most professors fulfilling the eligibility criteria to the governing body for posting the IC director till the regular director is appointed. From the date of the said recommendation, governing body will sit within 7 days therefrom and decide who will take the charge as the IC director till the regular director is appointed on the basis of the panel that will be recommended by the executive committee. Till then, opposite party number 3 shall be allowed to continue, but thereafter opposite party number 3 shall not be allowed to continue, and his engagement shall come automatically to an end in view of our order. We further direct the opposite parties number 1 and 2 to start the process of the regular selection of the process of selection of the director.
No, prior to that, we have stated that bylaw has to be
Just wait.
Yes. Sorry.
If any amendment is in the bylaws is required, that shall be done before such process begins. The entire process shall be completed within a period of 2 months from today. In terms of this application stands allowed and disposed of. Any grievance?
No, ma'am.
Don't apprehend that court will do something against you.
Grateful, ma'am. Grateful. A copy of the order so that I can come.
A copy of this order.
Well, if it is in course of the day, so that.
Habeas purpose first. Just wait.
Yes, in that case, which I have already completed my argument, my counsel wanted to submit.
Lordship, I have prepared a list of dates and events, Lordships. May I read slowly, Lordship? Lordships, my lord got it, list of dates and events.
Yes.
Birupa Degree College at Post Input District Kendrapada was established in the year 1982. The said college received government concurrence and affiliation with effect from session 1988-89 and became eligible in terms of clause 7.4 of the Grantinate Order 1994 defined under section 3B of the OA Act with effect from 1694 pursuant to the letter dated 29/5/98 by the Director Higher Education Bhubaneswar for reference lordship, that is page 31-32. Then Office of the Director Higher Education Bhubaneswar on dated 9/3/90 released direct payment of salary as per granted principle in favor of the lecturers who joined on their respective post with effect from 7/9/82. Petitioner was joined on dated 23rd/10/1991 in the second post of political science before the said college. On dated 4/1/2001, Government of Odisha Department of Higher Education further validated.
Verse he is reading from. Have you given us the list of dates?
Let's see. I have served
Not
long before.
It is show from the first item. I think it is the first item.
This is which item?
No, he's on the second sub item.
Second.
The first item. I think the list is the first sub item. Maybe he has tagged with this first item.
Oh, no. Oh, it is tagged. Let's see, if it is not there, I have got only one copy. List of dates are only relevant for
No, that's all, because you are reading from the list of dates.
that is only for factual aspect. Lordship wanted to
No, understand.
No, the factual aspect has nothing to do with this basis. If one issue is decided, I think everything will be
Lordship. For that purpose, straight away I am coming to the law. Lordships. Lordship, my first point, Lordship.
Yes.
I have challenged here the validity of 2009 grantinate order.
Yes. Yes.
My first contention is, Lordship, 2009 grantinate order is a notification which acts contrary to the 94 GIA order. Second aspect, Lordships, I am challenging the competency of the authority in bringing this notification, as because the authority is not competent under the law to bring this notification as envisaged in Odisha Education Act 69 in section 27. It is because, Lordship, the only legislator has the power to amend certain law. Lordship, for that first point, Lordship, I am taking my law to the book. I am not covering anything more. Taking the book, Lordship, Odisha Education Act, section 27.
Yes.
No avoid.
Yes, yes. On the other occasion, we went through this book.
Lordship, that is page 165. Page 165. The map records. Yes.
It is you are referring to now because section 27.
Page 165, section 27.
All right.
I am holding the same book, Lordship.
No, all right. It's there. Powers to make rules.
Lordship, that. This is very important, Lordship. The state government may
after previous publication, make rules for carrying out all or any of the purpose of this Act, plus two lordships, in particular, and without prejudice to the generality of the foregoing powers, the state government may make rules, lordship, this is important for me, to regulate the establishment, recognition and management of private educational institutions, B, in respect of all matters expressly required or allowed by this Act to be prescribed. Then clause 3, all rules made under this section shall, as soon as may be, after they are made, be laid before the state legislature. This is very important. Once this rule is made, it has to be laid before the state legislature for the assent. Let's see, kindly, I have given a memo. I have supplied one memo. In memo lordships, earlier I have filed lordships, page 1. This is the RTI report received from the Secretary of Orissa Legislative Assembly.
Yes.
Lordship got it?
Yes.
This is page 2, lordships. Para 1, lordship. Written information with regard to whether the Orissa aided college, aided junior colleges and aided higher secondary schools granted order 2004 has been placed before the State Legislative Assembly, Odisha, for discussion, debate or approval or for rectification. If answer is yes, then a proof of such note sheet or proceedings of the Legislative Assembly may kindly supply to him. Second, dealership, written information with regard to whether the Odisha aided colleges, aided junior colleges and aided higher secondary schools granting at order 2008 has been placed before the State Legislative Assembly, Odisha, for discussion, debate, for approval or for rectification. If answer is yes, then a proof of such note sheet or proceedings of the Legislative Assembly may kindly be supplied to him. Thirdly, lordship, written information with regard to whether the Odisha aided college, aided junior colleges and aided higher secondary school granting at order 2009. This is for my lordship. Has been placed before the State Legislative Assembly, Odisha, for discussion, debate, for approval or such rectification. If answer is yes, then a proof of such note sheet or proceeding Legislative Assembly may be supplied. This is important. In the above context, it is pertinent to mention here that the above mentioned order at item 1, 2, 3 have not been laid before the Odisha State Legislative Assembly to are verified from the register available in the legal cell. This is the that means what I am intending to say, lordships. The power envisages under the Act is only the legislature to amend the rule. It is not the executive. Because
what do you mean by that?
I mean to say that
placing a rule that has been framed before the legislature doesn't function as the legislative authority to frame any rules. There are varied kinds of the rules. The rule is also done by the legislative process, by the assembly, others by the executive, by the delegation of power, as you have pointed out, section 23 of the Orissa Education Act provides. What is the problem is that when the power of the subordinate legislation is provided in a statute and that has been exercised, and that also requires the confirmation of filing before the legislative authority. what will be the consequence of the non-filing or non-submission of those rules framed by the, under the authority under the subordinate legislation?
My answer to this, Lordship, it is a mere notification. Thus,
it cannot be given effect to.
It cannot be given. It's a mere notification by the executive. Utilize its excessive power as because Lordship is Odisha Education Act.
That is a very grey area. Why? It requires a mere placement of the rules before the legislative authority. Because of the knowledge whether the delegation of the power that has been made by the statute has been properly exercised or not.
That
unless they raise any objection. Your point is that was never done. Whether that has been properly done or not was not examined by the Legislative Assembly. At least they did not get any opportunity because for the non-placement. How you can say for this the rule becomes invalid?
I am saying to that effect, I am saying it is a notification. It is a notification. Notification which has been done by the executive.
Yes.
Therefore, intent of the legislature cannot be unsettled by the executive act. Let's see. For that purpose, I'm just touching more. I'm just brushing it.
Before that, because you are embarking on an area highly complicated.
Highly complicated. I know that's it. That's why I'm driving to that area.
I believe if there's a nourish your submission by you of the any precedent.
I have got the precedent.
Otherwise, you have to go by the general constitutional interpretation.
I'll go to that.
Yes.
Let's see why I'm putting this. I'm bringing first point.
Yes.
This is let's see Odisha Education Act. Let's see has got the assent of His Excellency the President of India. Odisha Education Act.
Mr. Nayak, I'm telling you, we must be very precise in submitting before a court. There is no challenge against the Odisha Act because it has been framed through the legislative process. Right? You have no objection.
No objection.
And you also show us that the 27 is the provision under which the rules can be framed. Correct? According to you only, the rule has been framed by the notification which you challenge now.
Not following the procedure of 7 of there.
Not following that is why just wait and hear me.
That's it.
And so far I did not get how the following the process, you are saying without following the process. I do not find any single instance to say the process was not followed.
Because it was not made with the legislature.
Subsequent thing, after the rules are framed, according to the authority granted under section 27, that to observe certain things, I think this is the purpose for the scrutiny by the Legislative Assembly when it is found that it was not exercised properly. But you will also find in similar the provisions under other various acts, there is no outer limit. This is a mere file. So if filing is an observance, so what will be the consequence of the non-filing on the notification itself by which the rules are framed? That is the issue we'll touch because whether the notification has any valid force or not.
That's for that purpose. I'm taking Lordship. Why I'm saying so?
Yes.
This Odisha Education Act, Lordship, has got assent of His Excellency the President of India in pursuance to List 1. Entry 66, Lordship.
Yes.
Lordship, I am taking list 1, entry 66, Lordship.
Why are you going all these things?
Why I'm going, I want to cover this first point, Lordship. It is because I am only to address my Lord. It is because
please value of the time of the court. Because there is no question relating to the act. And act provides section 27. You are not also challenging 27. So how the assent was taken, what was the process? It's a matter of no relevance.
I am only saying that 2009 GIA order application has not been amended or notified taking into consideration or in consonance with section 27 of the.
I reject this contention.
Because
just wait, I reject this contention because you have not appreciated the provision of section 27. It says that after the rules are framed, how the rules are framed? By publishing the notification. So the notification has been made, rules are framed. So another duty is cast that it has to be placed before the legislative assembly. So far this process is concerned, you cannot challenge it. You are none to challenge it because something has not been observed. And such observance only will entail, if required so, by the scrutiny of the principle, that is the legislative assembly, who created section 27. But so far the publication of the rules and notification is the thing. Where is the informative? Only that after publication, their duty. I am not taking the word obligation. Their duty to place this before the legislative assembly.
This creates obligation.
That's any precedent. Come straight to the point. That if certain thing is not placed before the legislative assembly, the very rules become inoperable. Just show this. As simple as that.
Now, second aspect, Lordship, I am talking.
Answer that question. I will not allow you to go to the second point without completing the first point. What is your submission in this regard?
I'll give the citation.
Give the citation.
I'll give the citation. I've got all the citation. I'll give the citation.
I'll give point by point.
This regard, I have got the book. I'll give the citation. Give
it right.
I'll give the citation.
No.
Let's see. I'll give.
You are insisting from the morning that I am fully free.
Yeah, sir. Unless I give it, I cannot succeed, Lordship. I'll give that.
Always.
Lordship, my second point is.
But we are not allowed to read the citation now. You just place the citation before us. Okay.
My second point is, Lordship, whether any change was brought by way of repeal order 2009 to better facilitate the employees in view of the earlier GI order 1994 with a match of time. Lordship, to this aspect, Lordship, I would only take my Lord to the act again, Lordship, troubling my Lord.
Yes.
Orissa Education Act, Lordship, was settled by looking into the object and statement of 13 of 1994, where object of section 13 of 1994 which says, Lordship, for the betterment and to facilitate the institution and its staffs, this assembly came into a proposal to bring a legislative intent by way of granting it to its employees.
Okay.
On that footing, this granting it order 1994 came and 7C was added in the Odisha Education Act.
Yes.
Lordship, kindly come to section 7C of the Odisha Education Act. Lordship. That is at page 137.
Yes.
My purpose of argument, Lordship, in 7C, Lordship, this granting at order 7C, who said for eligibility of the GI of the employees, there shall be a continuous post be held by the employees at least for 5 years. Thereafter, a relaxation was made in 94 GIA order, which says it is 3 years, 5 years, and 7 years. My point to argue in this matter, Lordship, I want to say this grant 7C specified the qualification for receiving GIA, that is tenure for 5 years. Now, again, it was it became stretchable by relaxing it 3 years, 5 years, and 7 years. Now, GIA order 2009, which came in effect from 2009, which says from 2009, March 2009, they are eligible to receive block grant. My confession to bring this action of the notification of GIA 2009 is contrary to this section 7C, Lordship. For that purpose, Lordship, I would like to read 7C, Lordship.
Not entirely relevant part. 7C is a very long provision. You read the relevant part.
Relevant part.
This
Lordship, 7C core. Touching. I'm just.
Before that, also read subsection 1.
Lordship, the state government.
Yes.
Shall within the limits of economic capacity set a part of sum of money annually for being given as granted to private educational institution in the state. This is what Lordship granting order to 94.
No, this is what the philosophy that the state government to do all the better things subject to its financial capacity.
Lordship.
It is not that always they will be making the grant and every year that will be growing up. That is not. That they will assess, they will give us within their financial capacity the annual grant in aid for the schools. That is what we understand as the block grant.
I'll take my lord.
Yes.
This aspect regarding the financial capacity of state government, it was argued in Profulla Sahu before the Honorable Supreme.
Exactly.
Honorable Supreme Court, I had the occasion to argue this matter before the Honorable Supreme Court. Honorable Supreme Court was pleased to reject the contention. I'll take your my lord to that SLP I have annexed in my petition. That once you are framed in a developed society, you cannot curtail any benefit and deny anything. It was rejected. Thereafter,
that there is a two aspects in the matter. One is the assured grant. Suppose some of the salaries and the other financial related to the employees, this is a assured grant was granted. In Prafulla Naik's case, Prafulla Sahu's case, that you cannot curtail that assured grant.
Assured grant. My contention before Lordship 2009, they have curtailed my benefit. That is, assured grant has been curtailed. My tenure did not Lordship. I have joined in 91. Somebody has joined in 89. Somebody has joined 94. But they say you will get all benefit from February 2009 Lordship.
Yes.
That assured guarantee has been curtailed by them. That's why on the first month by your notification.
Just don't just run over the process.
Let's slowly I'm moving.
Yes. That this is number one. First, whether there was any assured grant previously and that you have enjoyed. Number one, you have to satisfy this.
Yes.
And then show that assured grant was curtailed by the state government.
Yes.
And then, of course, there will be this Prafulla Sahu's case will apply. Though the Prafulla Sahu's case does not lay down any universal principles. It is decided in the very prospective fact of that case only. But you can take the nourishment as a matter of illustration that how the Supreme Court has dealt with that matter, that becomes as a part of the reasoning process. Right?
My humble submission, my lord, since my lord asking the question, in Prafulla Sahu case, after disposal of the Profuller South case till now, Lordship, they are continuing by paying many employers.
Inability I could not properly express to you. I think in the Profuller South case, there was assured grant and the government wanted to reduce it and there was a challenge. But here is a case where you have not given any grant. The government by way of the amendment notification says this will be the date in 2009 from which date you will grant all the benefits. Right? Have I read the notification correctly?
My lord,
Then it's two distinguishable situations. One, when there was an assured grant and someone enjoying on the basis of that assured grant, suddenly there's the things that by your block grant will grant this, that ultimate effect will be that it will be curbed. Supreme Court says, no, you cannot curb it because it was a part of the assured grant. When the grant has been just contemplated, you have not enjoyed any part. The Profuller South case cannot be in toto will apply in the present case. You have to make the distinction between the two different situations.
Because, Lordship, because by the time this act came, 2009 Improvement Act came, thereafter Lordship Profuller South case was disposed of.
It doesn't matter.
It matters.
These amendment rules were considered in the Profuller South case.
It matters, Lordship. In Profuller South case, they did not say. In the pleadings also, Lordship.
I'm clarifying more. Suppose we are deciding a matter of 1994, we look into, because the cause arose in 1994, we look all the relevant laws and the facts which were relevant for 1994. We'll give the decision in 2024. Doesn't mean that we are deciding a cause in 2024.
Lordship, I must not suppress the fact.
No, not. We are not deciding a cause of 2024. We are deciding a cause of 1994 only.
Lordship, I must bring to the knowledge of my Lord that I have come with a rule, I have come with an act.
No, that's true. But you don't say the Profuller South case because it was pronounced after the amendment rule was made in 2009. Therefore, the Profuller South case will have a direct bearing on that rule that you cannot argue. Because when they are considering the matters relating to 1989, 1991, 1994, they are conscious of the rules that was governing that area at that point of time. At that time, there was no concept like the block grant.
No.
Block grant was only introduced in 2009,
2004.
After that. So this fact will not be relevant for this purpose. All right, you just continue. I'm just pointing out the things you must keep in your mind. Yes.
In that aspect, Lordship, kindly come to 4A, Lordship. 7C4A.
Yes.
The granting aid to be borne by the state government on account of placement of the teachers in an aided education. Let's got it?
Yes.
I am not touching all this. I am only wanted to show that 5 years is the tenure. The granting aid to be borne by the state government on account of placement of a teacher in an aided educational institute receiving university grant commission scale of pay under the career advert scheme shall be limited to the extent as may be admissible by computing the period of service rendered by him against an approved post with effect from the date of completion of 5 years of service against such approved post. This is what this 7C Act says, Lordship. It must be an approved post and he must have completed 5 years of tenure for getting GI, Lordship. Then 4B, Lordship. Notwithstanding anything contained in any judgment, decree or order or of any court to the contrary, any instruction issued, this is important, Lordship. Action taken or things done on or after the first day of January 1986 in regard to matters provided in section 4A shall be deemed to have been validly issued, taken or done as if the subsection were in force at all material point of time.
Yes.
Then, Lordship, I'm just taking my Lord to section 28. Or relevant for the purpose, or right, accrued Lordship is saved. The saving clause, Lordship, 28.
Yes.
168, page 168.
Is 168.
In the book, page 168.
Yes.
Savings.
You're reading section 28.
28, let's saving clause. The provisions contained in this act shall be in addition to and not in derogation of the provisions contained in the Odisha Secondary Education Act 1952 or in any law regarding university education for the time being in force. This is important, my case. And in the case of any inconsistency or repugnancy, the provisions of this act shall prevail.
Yes.
What I am submitting before my Lord, 4A stipulates 5 years against the approved post.
Yes.
Now, 2009 say, even if you are continuing with an approved post, you shall be eligible to receive the GI by block grant from February 2009. Therefore, this hits section 26 of the saving clause. This is important. In the case of any inconsistency or repugnancy, the provision of this act shall prevail.
What does it mean?
Lordship, anything done contrary to the act, Lordship, this, my right, which is accrued under this act, is protected.
That shall prevail.
Prevail.
All right.
Lordship, for that purpose, I'd only give one citation. The right accrued is saved. Did you do it?
Only the relevant part you show us.
Let's see, just I'm touching the placidum of the judgment. I'm not going to read the judgments, Lordship.
Yes.
Manoj Rao, ଟିକେ ମୁଁ ଚା ପିଇନି.
Which one first?
Let's see, page 88.
I would take.
The Bombay High Court case.
Let's see. Then other Supreme Court judgment, page 88.
Yes.
Right to statutory right is conferred on persons qualifying prior to amendment. Statutory right is conferred on persons qualifying. This is important. Let's see. Placidum 1, let's see. 88. During this, I'll mark all this judgment. Mark with the flag. Mark with all the flags so that it will be convenient for my Lord.
All right, next judgment.
I have
things to say.
those copies will be supplied to us so that I can verify all those judgments.
Lordship, kindly see 20 judgments I have given the citation who wanted all this.
You just get the reference so that we can download.
Already you do this index space you just furnish to him.
Yes.
At least it is your duty to furnish the index space. I cannot ask you to give the copy of the judgment, but index has to be supplied to them.
Note copies. Give us the copy so that we can go through it.
All right, we will continue. But after the two matters are over, we'll continue today. And in the meanwhile, you give the index of these compilations to Mr. Here.
I had mentioned one matter. I had mentioned one matter. I had mentioned one matter 87, my lord.
After this matter, we'll take up. You just wait today.
I have also mentioned one.
These are for admission that we'll take up. We are showing the citations.
No, Lordship. I'll go point by point.
If you go point by point,
7 points. I'll go take only 7 into
what is assured to take. So this we'll try to take up this matter. So you go to the another page there. I think that would be proper. Because if you go by point, I do not curtail your right to make submission before this.
See, that's why I'm not reading the judgments. I'm not reading the judgment. Only I'll read placitum, then point. Only 35 minutes more.
More 35 minutes. And that's to lawyer's time.
Because Lordship, I have entered into a grey area.
Right.
Lordship, no.
I have already entered into a grey.
Lordship.
All right. The next to Mr. Muduli's matter we can take within 5 minutes.
Yes.
30. 30.
Yes.
All the 3 will is for admission.
Item 30.
This appeal has been filed by the state challenging the order of the Honorable Single Judge in setting aside the confirming order regarding confiscation of the vehicles seized under the provisions of Odisha Forest Act. In fact, there will be a delay of 329 days. And now, in the meantime, contempt has been filed, and this is the order passed in the.
What is the wrong in fact filing the contempt proceeding after 325 days? You are filing appeal. Mr. Muduli, what is this? We will not issue any stay order. When an order is passed, you just slept over, or you decided that you will comply it, and suddenly, when the contempt proceeding has been filed, you are filing an appeal.
That is the fact, my lord.
We are issuing notice, but we are not issuing an interim order.
Only your lordship grant us liberty to seek for an adjournment in contempt petition. Because direction has been issued for personal appearance.
Because what to do? You are sleeping for a year. And suddenly it is a Rip-Winkle situation. You come up and say that I have, then I stay the order. Where the people will go? They just start ignoring the court proceeding also. It's not done. I'm not entering this kind of step.
Direction for release of the vehicle.
Yes.
So?
Okay. That the vehicle was.
No, that is all right. But release of the vehicle, that is not going to affect the law or anything if you change the release the vehicle.
No, if ultimately tomorrow this writ appeal is allowed.
But tomorrow they will be already given you the protection that the vehicle should not be transferred to any person. Except that he should keep the custodian.
You lordship, with that condition, you lordship,
you release it.
Simultaneously, also, my lord, take the proceeding of contempt.
Additional government advocate appearing for the applicant state who filed the stop application. This is an application for combination of delay of 329 days in filing the intercourt appeal against the order dated 38/2022 was the single judge in WPC number 12534/2020. So issue notices to why the aforementioned delay shall not be conduct or any other order or order shall not be passed. Notice is made returnable on the 4th of October 2023. So steps for service shall be taken on the sole respondent by registered post to sole opposite party by registered post to AD. Yes. Then I number sentences. Oh, you have also not filed the certified copy.
It is filed.
Filed or not filed? Application is there for dispensing.
It has not been filed. You'll also grant some time. I'll file.
All right. In 5753 of 2023, but Mr. Mudali, there's an application for staying the operation of the impugned order dated 38/2022 was by the single judge in WPC number 1233534 of 2020, by which and single judge has directed the appellant to release the vehicle
in favor of the respondent owner.
In favor of the opposite party, who is the owner of the vehicle, which was seized in connection with, it was seized and was made the subject of a confiscation proceeding under section 56 2A of the Orissa Forest Act.
Confiscation proceeding number 14 of 2019-20.
The confiscation proceeding number
14 of 2019-20.
14 of 2019 of 2020. So, you see, proceeding was drawn for the violation of section 27 within bracket 1 within bracket small a of the small and 3, then small b of the Orissa Forest Act 1972. Page 22 is the reference in the 4th line. So, the vehicle is a tractor with trolley. Am I correct? It is a tractor with trolley. All right. We are not inclined to pass a blanket stay order as the appeal has been filed after about 1 year. Stop. But for ends of justice, we direct the opposite party shall not transfer the said vehicle to any other person, or shall not give the possession of the said tractor and vehicle to any other person. Stop.
Also not to deface the vehicle.
Huh?
Also not to change the
color, and also not to change the vehicle in any manner. Change the nature and the nature and the not to detrust any parts of the vehicle to make it inoperable. Stop. It is also made absolutely clear this order will be revised by us subject to the order that will be passed in the REIT appeal. Stop. The opposite party is given liberty to approach for any modification of this order In terms of the above, this interlocutory application stands disposed of.
Contempt.
What contempt? Contempt you face.
Pursuant to my lord's order, we will release the vehicle as an interim measure.
There is a compliance. You have not stayed, you release it. But release it is subject to these conditions.
Yes.
So where is the contempt? Go today itself, you release subject to these conditions of this order. Is appearing for these.
Yes.
46.
Is appearing for the.
I am the petitioner.
No, responding to my opposite party.
The state is there.
Item number 7. State is there. My learned friend appears for VD and my senior friend appears for municipality. So all are before your left.
So have you gone through the report?
Yes, my lord. I have gone.
Also filed the objection.
I have also filed my objection, my lord. But can I just place that first, my lord?
Obviously, from that point it's done.
Right, my lord. But before I place the report, I would like to bring your lordship's attention to the order dated 3/3/2023, my lord. Your lordship heard the matter. From just first paragraph, the paragraph 2, my lord, having regard to the nature of controversy. My lord, got it, my lord?
Yes.
Particularly in respect of advantage of the road having width of 200 feet running adjacent to the plot of the petitioner. The petitioners have challenged the realignment of the road and allotment of surplus land to the opposite party number 7. The plan approved by the BDA, Bhubaneswar Municipal Corporation, for construction of the house of the petitioner, later dated 18/6/2015, Annexure 3 to the writ petition, has been brought to our notice. In the permission letter, it has been clearly mentioned as follows. The land over which construction is proposed is accessible by an approved means of access 60.96 meters and 9.14 meters in width. That is approximately 200 feet and 60 feet respectively. Similarly, in the certificate of delivery of possession dated 7/8/2010 under Annexure 2, issued by the Bhubaneswar Development Authority, the boundaries have been indicated follows. The description of the boundaries there: north 200 feet road, east 30 feet road, south plot number 1190, west some hospital. Delivery position is given and taken by him. According to Mr. Parul, our senior counsel, who is representing the petitioner, for giving permission of G3 storage residential building, the said road, which was supposed to be constructed by the Bhubaneswar Development Authority, had taken into consideration. Now, for relocating the road or for discovery of the surplus land by the survey conducted by Settlement Authority, the petitioners are going to lose their direct access to the above road. It has been fairly stated by Mr. Mahapatra, when as standing counsel appearing for Bhubaneswar Development Authority, that when the tract of the land was given, no actual survey was conducted, but on the basis of cadastral maps, the layout plan was designed and demarcated to the intending purchaser.
But when the field level survey was carried out, the surplus land was located. The said land has been handed over to the GA department, represented by Mr. D. Naik, additional government advocate. In turn, the GA department has allotted the surplus land to opposite party number 7 for their use. In this transaction lies the genesis of the controversy. That is how Your Lordship summarized the facts. Prima facie, we are satisfied that based on layout plan and the petitioners purchased the land, the advantage of direct access to the road was assessed by the petitioner, but now the advantage has been done away with. It has been asserted by the petitioners that while taking the decision to take the land, there should be a resolution of that controversy, but that cannot be found on the basis of the record only. In the circumstances, we proposed a committee of the technical persons to be formed, and such committees have been formed from the 3 technical persons selected by the major stakeholders, such as GA Department, Government of Orissa, Orissa Development Authority, and the Revenue and Disaster Management Department Settlement Operation. Each of those departments would select one technical person, adopt in surveying the land, holding a position to suggest that alternatives in the report how the adjustment can be made, keeping number 1, the advantage that was granted to the petitioner intact or minimally adjusted. This first. Second, how the petitioner's access to the 200 feet wide road can be maintained. We also direct the proposed committee to support their alternatives and suggestion by map so that it can be easily understandable by all parties who are involved in the controversy or who have stake or interest. We direct the GA department to coordinate the formation of the committee. Such committee shall be formed, and then etc. committee has been formed and report has been given. But if Your Lordship looks at the report now, we're trying to see the report. Well, with due respect, the faith and belief that the court had on the 3 departments has been frustrated with due respect. The reason being, the 3 questions that was put forth by Your Lordship, that has not been answered at all. If Your Lordship kindly see the report dated 15/3/2023. The committee members are Ranjit Das, Assistant Settlement Officer, Anil Kumar Das, Assistant Director, and Sri Mamita Mahanti, Junior Town Planner. On verification and after going through the land records and record of BDA, GA, and PG department, the detailed position of the case indicated below, at an area of 4,219 square feet bearing plot number 8K, K81190A under Kalinganagar plotting scheme in Mauza Fatiga allotted in favor of Sri Vivas Mahapatra and Gitanjali Mahapatra for residential use in the year 1995. Revised in the 2003. Possession was handed over in 2010 as per the drawing prepared by BDA. The so-and-so was boundary description, north 200 feet road, south plot number 1190, east 30 feet road, west Sam Hospital. Bhubaneswar Municipal Corporation by letter 18/6/15 has given permission in favor of petitioner for construction of G+3 storage residential building. So cause notice, but kindly see how they proceed, my lord. They are trying to find out the fault with me, the petitioner, and how to projecting it before Your Lordship. So cause notice was issued to the allotee by BDA on the later number so-and-so dated 25/7/18 regarding deviation of approved building plan and encroachment of government road land and using the building for commercial use while approval has been given residential use. The Additional Commissioner of Enforcement BDA has submitted requisition before the competent authority BMC for initiation of unauthorized proceeding under the Odisha Development Authority Act. The case was detected in 2018. The matter was referred to BMC for initiation of UPA case, and BMC was authorized to initiate such case within the municipal area.
You continue.
The case was referred to for Should I continue? My lord?
Yeah,
Yes. The case was referred to for recession UPA case due to following reasons: construction of building by deviating approved plan, use of residential house for commercial purpose, encroachment of government land, government road. Now, kindly mark the word encroachment of government road. That is one of the important things they say. With due respect, I'll show that. No lease deed has been registered in favor of the allotment till now due to violation of deviation of approved building plan and commercial use. Procedure of allotment has not been completed till now. At present, allotee plot K 81190A has been bounded by compound wall. Kindly mark, my lord, on the north side there was no boundary wall. The boundary wall on the back side, that is on the west, east, and west, east, and south. The 30-feet road exists in the eastern side of the road plot as a layout road of the scheme. The petitioner has unhindered access to 30-feet road, also to 75-feet blacktop main road, to 200 feet CDP proposed master plan, though through the 30-feet wide road. Even though 200 feet proposed master plan road has been shown in the CDP, currently 75 feet wide blacktop road is existing in its place. But I'll just pause here a moment to explain the lordship one thing, my lord. Can I explain, lordship, my lord?
Yes.
Well, kindly have a look at this desk, my lord. This desk is gradation is there towards this side. The land is here, my lord. The 30-feet road is sloping upwards like a hilltop. It's going up and up. I'll show the photographs to you, lordship. There cannot be any approach from the side of towards the eastern side to the road. In the end of my plot, I had to use, after the construction of the wall is there, a grilled iron pathway so that I can go up and go to the 30-feet road. No approach can be made otherwise. This side is the 200-feet road. After the slope meets there. After about 30 feet. And the land is in between that. And so the position of the land later on. But therefore, this observation of the three members is with due respect contrary to the materials available on record. 75. And one thing they have also indicated, which is glaring the face of it, but it says CDB plan says 200 feet width road, blacktop road, Marad, is now existing 75 feet. If lordship accepts that, the divider goes in between at 75 feet. So each side should have been 100 feet. Now each side is not 100 feet. The other portion of it is on this line itself.
No, this road is not measured that way.
No, I'm not on that. Sir, what I wanted to show you, lordship, exactly, I don't want to drive into all those things to lordship. What I want to show, provision says that if I have a plot of land, then I have to have my face, opening space, towards the wider side of the road. That's the rule of law. I'll show you, lordship, the provision of law that is existing. Not the smaller portion of the road, which is if it's a corner plot. If it's a corner plot. But all my openings are towards the 200-feet road. There is no obstruction, and all doors, everything opens to that side. Kindly visualize, my lord. The plan approved.
Just come to their map.
Yes, my lord.
The map.
Let me take your lordship to the map. Right. So this report contains a map, my lord.
Yes.
So in a CDP, no. Report map. But this report map, with due respect, my lord, is a reproduction of the map filed with the government. Kindly see with this map, page 107.
Yes.
So kindly see page 107, my lord. Then I take your shift to my map itself.
All right.
Just for a lordship's appreciation. Page 107.
107 of?
107 of the brief, my lord. Pagination, I think my brief also correctly paginated.
10.
So this is the counter filed by opposite party 1 and 2.
1 and 2, yes.
Yes, 1 and 2.
Got it.
Annexure A by 2. But I got that A by 2, same thing has been reproduced here. But with due respect, what the master might have done, the bottom portion, they have put a paper and erased it and taken a photocopy and signed it, my lord. Because they cannot draw it again. It has not been drawn by them. Your Lord said they should show it from the map itself, the identical. And interestingly, if you look at this map, this government's map and their map itself, can you see the SOM hospital, which is there in the red portion, is a huge area. In front of the dotted line is the portion which has been allotted in their favor. But the green color, blue color that is given is my plot, my lord, Pritzner's plot. But I got that green portion. I'm sorry, blue.
The original record is showed.
Color tanegi.
Now, so already is understanding the dotted lines are there.
So this is color, they have given us colored picture.
That is true. 1 and 2.
107.
Showing me right now, no? But like.
Page 107. हाँ देखिए ना. हाँ. Yes, it's there now.
The colors.
The small blue portion, my lord, got it? That is my plot. No, dotted line is a continuous patch of line. 200 feet road doesn't exist.
Yes.
But this portion is a specific area which is in front of the petitioner's land, which is not continuous. But the adjoining west side is used as a road by the SOM hospital to enter into their hospital itself. The photographs I'll show you. The total area it is given, it is adjacent to SOM hospital, then thereafter the 200 foot road. But they could have given to this extent, not in front of the petitioner's house. They have completely obstructed my outlet.
But what about the 30 feet wide road just back of your plot?
The wall, Malad.
No, 30 feet wide road. Just on the back side of your plot.
So my backside is the another plot number 1190.
No, not that one.
Here it is not shown, Malad. They have not shown anything. They have only shown the 30 feet road.
Yes, we are asking about that road.
Yes, Malad.
Yes.
30 feet road is right inside.
Yes.
So that's a slope. That's a slope, gradation downward. His height is about, so far as my house is concerned, is about 8 to 14 feet in difference, Malad. From the north side to the south side, it varies from 4 feet to 14 feet.
Mr. Mahapatra, where is he?
No.
Hey, Mahapatra, just do you have the colored map in your hand?
Just now, that is my comment friend as supplied.
All right, just come to this. There's one purple and there's a blue. Two color has been used in the map.
What is that purple area?
Yes, ma'am.
That is allotted to some hospital.
Can you just tell us the measurement of this purple area, because that is what the land has been allotted to this SOA University. Can you give the measurement of that land in purple?
86 decimals. That purple portion is 86 decimals of. It varies between 60 feet. The weight between the petitioner's plot and the road, the demarcation of the 200 feet road, it varies between 60 feet to 100 feet.
No.
Mentioned in the right side.
No. This yes, right side there is this purple square is there.
That area is mentioned.
That is
mentioned as suit.
Actually, it is 0.8 acre.
0.086 decimals.
0.86. Actually, this is a point is a 0.8 acre, very small portion of lot.
0.086.
17 or
if you convert it to the acre from the decimal, it will be the 0.08 acre.
And 0.8.
Because otherwise it is 86, 0.0886 decimal.
0.0086.
Out of 1,000.
1,000, exactly. 100, inside 186.
In so far Bhubaneswar mallards, we follow 1,000 decimal.
And obviously, that is why you are writing correctly.
0.8.
But if we convert it into the pure unit of acre, it becomes this 0.08 acre.
Obviously, conversion by divided by 1,000, it will be 0.006.
So it is not a very big portion. Maybe this bigger than this room only. Much little bigger than this room only.
Right. But what has happened actually,
Mr. Mukherjee, that you have given this allotment of the entire road shown by the dotted line, blue dotted line.
Yes, blue dotted line. Yes, Manoj. That has been given, leased out in my favor.
So
Can you do a little sacrifice?
master plan road is the gray area.
Yes.
No, gray area is the
Master plan.
that question would come later. In fact, I'd filed an application earlier. If your lordships will kindly take that up.
The modification will take.
Yes.
That will take. Just wait.
My lords, what the difference is this, my lords. This has been
just what I am suggesting. Just hear it. That whether that small amount of land can be taken out of your land that has been allotted to you, because it will not affect anything of your interest, because this is the right side corner.
That is where the OPD has been planned, my lords. In the expansion program.
Because when the land was when the proposal was there, they are showing that he has an access to that.
He never had any access to that land. I will show it to your lordship. I'll show it to your lordship that he never had any access.
No, the physical site area when shown they shown that area that their access will be there. When Mr. Mohammed is not there. So you are the recent occupier there.
Yes.
Between
2017 and 2020, when it was leased out in my favor, this land was under the occupation of the municipality. And the municipality was leasing out this particular portion of land for parking facilities. And the entire area was blocked. He never had any access there. In fact, I will show it from his approved plan, building approved plan, that his entrance is from the eastern side. I'll show it from his own plan, which he has annexed to the writ petition. His house orientation is facing the east.
Let me clarify. With due respect, I know the entire thing. I have gone there myself. I want a senior advocate, maybe deputy, to find out whether the truth and all that. But by the side of my line, the other side is some hospital side. It's a wide road of about 25 feet. Wide road. this particular land is detached. Is a specific portion, not at the dotted line.
We are not coming to the uses. What, how it is.
Sir, kindly look at the photograph, my lord. Kindly look at, I'm giving now, my lord. Kindly just look at the photograph, my lord. So the practical aspect of it, my lord, kindly look at that. With your lordship's permission, my lord. I have marked 1, 2, 3, 4. Kindly look at that. NCI. I have written it in ink one word. One is this is before any construction of that boundary wall. Kindly see the shop is there, that medicine shop is there. Right hand side, all openings are towards this 200 feet road. This is from the road itself, the photograph has been taken.
Yes.
Second photograph you can see.
Yes.
This is also from the road. Can you see the passage?
Yes.
Approaching the hospital, that medical store. There is no obstruction on it. It is from the road itself. Some scooter, the motorcycles are parked in the right side because it's a municipal line itself. So can you see the third photograph?
Yes.
This was after it was leased out, they tried to put some earth on it, not to level it. All opening was like in the road. Has you also got it, Manoj?
Yes, yes.
Then the next one, actually, can you see? The fourth one. Fourth one, the left side is the western side of my house. Can you see the depth of the house from the road?
Yes.
Right side, the east side, where they say the 30 feet road. Right side, Manoj. See the gradation towards the 200 feet road, the height from which, because Bhubaneswar is a hilly area. Some places high, some places low. Can you see the fifth photograph, Manoj? There's another angle showing the eastern side of it. The gradation of the road and the height of the road and the building. Can you see the next one? Sixth one, Manoj. On the western side, this is the entrance to the SOM hospital, Manoj.
Yes.
It's not a continuous. This patch of land is to the left.
Yes.
A road is there. My building is there, shown in the map itself. So there is no continuation. There is a big gap between the SOM hospital and this one.
Okay.
So kindly look at the seventh photograph, Manoj. Now they have put the boundary wall. The boundary wall is in front of the house itself.
Mm-hmm.
Eighth one, as we can see, the road to SOM hospital is visible here specifically. This is the road existing, which belongs to SOM hospital.
Yes, yes.
The ninth photograph, what we kindly see. The temporary amendment I have to make, prepared a grid slope to go to my place. The wall is existing in the right, which they have put.
Yes.
Copy number 7 has put it. I cannot go from any other side. Eastern side, I have to prepare a slope to go.
Okay.
So this 10th photograph, my entrance to go to the upstairs, that is from the north side itself. So the 11th photograph, the wall itself is there on the edge of my land itself. The height of the road and the building can be seen from the 12th photograph. Height in the building. On the end of my house itself, the height will be about 4 feet. More than 4 feet.
And your lordships.
And just one second.
I kindly see these photographs because.
But same place. It can't be something different.
But are you using it for your residence or for commercial purpose?
Sir, I'm giving it for nursing home.
No, guest house.
No, that's right. I'm sorry, guest house. Sorry, extremely sorry.
Guest house.
It's a guest house and a medicine shop is there.
And the 4 feet to 10 feet or 15 feet.
So that
Absolutely non-existent, as your lordship will find. The same elevation as all the other roads, all the other houses facing the eastern side. That's
all other houses, their first floor height is my first floor height is their ground floor.
Now, if your lordship sees the second paragraph, your lordships will find that the boundary is there, the ground is paved, which was being used as a second photograph, paved, which was being used as parking long since. First by the municipality before we took it over. And then your lordship sees the third photograph.
No, only thing there was no wall there.
There was no, it was to a certain extent, it was there, I have raised it.
No.
And now your lordship sees the third photograph. There are these permanent establishments which have, roadside establishments which have been there. There's a tree intervening the petitioner's plot and the road. And if you're now, at this juncture, if your lordship will kindly see the approved building plan, it is absolutely clear that the elevation of the house faces the east, not the north. It cannot face the north because no residential house can be given an access to the main thoroughfare. In any town planning scheme, it is always the ancillary road to which all residences are placed to.
Sir, kindly look at my objection to the report. My objection to the report says 94. Objection to the report was 94, man. Annexure P8. Running is 94 in that objection.
No, 1230, we want access to the rest of the
Access is there too.
access is there with broader exposed.
We want direct access.
You have got that objection to the report?
Yes, I got it.
It was 94, Malad. So the photograph has been taken on 21st August 2021. From the road, 200 feet road, it's not 200 actually, it's 75 feet road. Because the other person is there on the land itself. That has not been done so far. They are trying to raise the pillars and the boundary wall. There was no boundary wall existing at that time.
No, Mr. Mishra, this photograph, so here it is open. Here there is a wall, this side.
So this is the gradation of that road.
No. Here there is a wall. In front of that Sanjeevani shop, extension. There is a wall now, I'm asking. Now they have constructed a wall.
Yes.
But here it is open.
So that side is level, the east side.
This side is open.
East side is open.
Here they made a wall.
No, that is not the wall. They are bounding the wall.
No, they have not obstructed the 330 feet road. They are nowhere.
Guest house, there is no wall.
Yes, in front of that there is a wall. The wall covers the entire thing.
No.
This is not correct position. That what you are saying is come to their wall is along the 200 feet wide road.
That Sanjeevani.
There is a 200 feet wide road. They have constructed a wall. Soha University.
They have constructed a wall on the north side, east side, west side, south side. They fix a gate. The entire thing has been walled. As a result of it, I can also come out and go to the eastern side, except using that slope.
How you made the arrangement? Steel steps are there.
Yes, I have used that iron grilled one, not steps or slope. I'm using temporarily. I have to do that because I cannot go out otherwise.
Submitments. There are two roads attaching so far that particular plot is to north 200 feet road. That is called CDP road, old CDP road or CDP road, whatever may be said. The layout road is 30 feet to the east. If any means of obstruction in respect of that particular plot or in their front, just to reach at the 30 feet road, arbitrarily it is my lord's sucking. We have to demolish it. There is no way. No one can, because this is the layout road. Many of the people that are using it, and that is meant for the persons to whom these plots have been allotted. So this, if this is so, to the east side they have undertaken any construction, they have to remove it, because they cannot obstruct. So far as well said that slope and all these things, you have gone there, seen there, and thereafter you agreed to abide by that with layout to use the layout.
The other thing, Mr. Mahapatra, did you acceded to the statement made by the counsel for the petitioner that when you show the physical map?
Yes.
And also this shown that you shown that the 200 roads should be accessed by them from their plot.
Yes. No question.
No, now you are saying a little bit change you have made you something.
No, I think access that I will usually one thing. And let me ask you that map itself. That map measures that they have given. Okay.
Yes, absolutely.
The allotments. Plus minus could find. Well, that is in that 1190 corresponding to half number circumstances. This is the plot in his plot. In the front of that plot, 30 foot road is there. It touches to the main road.
Yes,
it is the layout road. The layout road here it was 200 feet. Now that blacktop pitch and all these things, 75 feet are there. The rest of the portion are there. In between, my lords, during settlement, they found out if that's a plan available. And out of that,
why this kind of an excess part of the dotted plot that comes to the map that has been given to that university? Alignment was it cannot come to that.
That is correct.
Alignment cannot go to them.
Yes. Well, that is because of the fact that this allotment, a patch of land was given to the BDA for creation of a housing
complex.
The colony. And there is no complaint from any quarter whatsoever that the area which was given to BDA by the government is in any way there is a shortfall or anything of that sort. Now, the settlement in Bhubaneswar in this area was completed in 2013. That is much after the allotment was made. When the settlement operations took place, they discovered that there are a patch of government land which is available after taking care of the land allotted in favor of BDA. Obviously, this land which was surplus belongs to the government, and the government has leased it out subsequently. So that is the position. So in 2010, when the allotment was made in favor of the
Mukherjee, that because of this mistake or the completely
I understood it would have been a mistake had it been mentioned in the lease.
We fail to understand. We are having the very small amount of intelligence, but without any physical and this survey by the government, how the design of an area can be made. And that also handed over to the BDA, they will develop this plot. And now later on survey is made. And some area are found to be the access and found to be under the control of the government. So some area you have granted to them this university. And university is fighting like anything. They don't like to coexist as neighbor with the other people. Otherwise you had come with a proposal that we will break down this wall, keep this open. They also allow you to park the vehicles there. I think matter could have been resolved that way. Another thing, his husband, his shops, the frontage is now covered by the wall. That is the only disadvantage is right now.
I could have understood had it been his frontage. First of all,
forget about the entire building.
The second thing is, he could have asserted a right which is there in his favor. The fact of the matter is that there is no right which is accrued to the petitioner as of now.
So we'll do it.
No right has accrued in his favor.
No, because
what about the lease deed? Not lease.
Lease still there. There cannot be a lease because he has violated the building. He has deviated the building plan.
I don't know.
Till he corrects that.
If there is no lease, how they can grant permission to no question of lease. But there's no question of grant of lease now. Well, that's a different aspect altogether. But lease can only be granted if BDM is allowed to execute the lease deed.
Just can it be that you just broke that part of the wall?
Whatever OPD is planned there. OPD
He cannot do it
planned there.
No,
The entire building, the plan which has been conceived of, I badly need an OPD. In fact, there are patients who have been turned away because I do not have an OPD. My OPD is planned.
This plot, you need this only that plot of this.
No. OPD, the plan of the OPD is such, it has to factor in various things. And the way it has been approved is that the OPD is situated exactly on that piece of property.
No, now this from your photograph it is shown, it is being used as a parking lot.
It is being used as a parking lot because of the restraint order which has been passed against me. I am not able to be on that.
You mean to say that this wall was constructed
prior to the restraint?
No.
Yes,
But during a complaint case goes to the police, nobody listens. They are much powerful, Malad. With due respect,
they must be powerful.
Very powerful. But I'm not saying that, Malad. Just one thing I would like to say.
Very powerful person.
Sir, the comprehensive development plan they have given page 33, can you see? This area cannot be used as a hospital part, Malad. Page 33.
What is that?
Brief, Malad, page 33, annexure 6. It's a notification dated 7th April. This CDB plan still holds good. It's a CDB plan, Malad.
Yes.
Annexure? No, I got that.
Annexure 6.
Annexure 6, page 33.
The one plan is a page 32.
34 is the map.
34 is the gazette notification.
Yes, gazette notification. Thereafter, a map is attached to that. Yes. The CDP map, colored map like this.
We are colorblind because of our scanning system.
Scanning to pen. No, scanning is not real. I understand. Kindly see the colored map. Well, my eyesight is not that sharp, but if you can see, some hospital is there, Malad, in the CDP map. The yellow portion is residential use zone. Can you see my plot is there 1190A on the top, Malad. Yellow portion touching the brown one.
Yes.
A gray one. Some hospital in the left side, Malad. The red one.
1190A is whose plot? Your plot? It is my plot.
So my plot, 1190A. That has been given to me, allotted in my favor. That touches the 200-feet road. You got it. And secondly, this is a residential zone.
No, that Mr. Mukherjee has explained this part. That when these things were done, there was no actual physical survey of the land.
So this CDP map has not been changed. It still holds good.
CDP map, my lords, is under the Odisha Development Authority Act. That is also specifying the areas for the particular use. Red color, blue color, black color, and yellow color. That is that. Yellow color means for residential use, and then our regulation specified the permissible use under particular zone. But here in this case, the situation is that the settlement authority during settlement, when the transfer whole total position and field, they found out the surplus area. In fact, then by the time we developed and the land is given to us, it was completely barren land. It was not even accessible to use there. So enter into there and to make a detailed survey. And that has caused the problem. I admitted in my counter, I admitted that I caused the problem. And that particular area has not been given to us. This residual area which has come out during settlement operation, this area has not been given to us. Obviously, the geo department is the owner of the land.
Sir, what are you saying?
Well, settlement map is a revenue map. It prevails. CDP map is only land use. It specifies the land use. There might be some difference.
Counter say we gave it back to the state.
No, we gave it back to the state means that the land available is not available to me. So obviously,
so this OGLS rule says, rule 4 says principle of allotment. Can you just read it, Malad? It says all applications for lease of government land shall be submitted to a director of the state. The application so received shall forthwith be entered in the register. The director of the state shall either himself or through the subordinate officers scrutinize the contents of the application about such other matter as are relevant or to the question of allotment of land with reference to the existing record of right. Then verify the land use plan as per the comprehensive development by BDA, prepared by BDA. Then subclause 4 says, after making necessary verification required under subclause 3, the director shall draw up a list of allotments to different purpose and he considered deserving as due list. And thereafter land allotment question will arise. But if they verify it,
that we all understand, that is what, but in this side that was not actually followed.
So
the physical map.
And interestingly, if you actually looks at where shall I open it, there's a specific rule to that effect. Can you have a look at the rule? My house would be open to which side? I've given it that miscellaneous case. Can you look at page 70, I think. Page 26 of my objection to the report.
Yes.
At page 30, if you also looks, what's the meaning of corner plot?
Page 30 of the objection to the
objection to the report. It's a Gazette publication on 26 May 2018, page 26, PY4.
You are referring to page
26, Malad.
Yes.
That Gazette, Odisha Gazette, Malad.
Yes.
So page 30, kindly turn, Malad. Mine was a corner plot.
Yes.
The corner plot has been mentioned here. Clause 33, Malad. Corner plot means a plot at the junction of and fronting on two or more intersecting streets. In such cases, frontage would be on the street having larger width. And where two streets are of same width, on the larger side of the plot will decide the frontage. The location of the garage so-and-so is there. But mine is a corner plot. There is no dispute about it. And let's kindly look at Annexure 17, the brochure, Malad.
147.
Yes.
147.
So 147
of your petition.
Yeah, brochure is there, 144, at page 144. At page 147. Clause 5, Malad.
Your page number?
Page 147, Malad. Clause 5, Malad. the cost of the land along with cost of development of infrastructure will be approximately 6.5 lakhs per acre. The cost will be charged according to the actual area of the plot allotted. Additional 20% premium will be charged on the original premium of the plot for the corner plots at the time of allotment. They have taken 20% additional amount provided with the corner plot. Well, I would like to explain, my Lord Justice.
What you are referring to? Page 147.
147, the brochure, my Lord, which I
brochure, the 147 is
147, my Lord.
Yes, yes.
Clause 5.
5 in addition to this part.
But before deposit of EMD. It's in a dark color, it is mentioned, highlighted, my Lord. Additional 20% premium will be charged on the original premium of plot for the corner plots at the time of allotment.
So you have paid that part.
Yes, my Lord. I paid it and that was allotted in my favor. That's the reason why it has been allotted. But my Lord Justice, Ratho, my Lord, wanted a question which is very pertinent, my Lord. Can I just explain that, my Lord?
Thank you.
I think page 20 I found it.
No, Your Lordship wanted by showing that photograph, whether on the eastern side, the wall is there or not, my Lord.
Page 20 of your objection, just look at it.
Yes, press 20, my Lord. Thank you.
The 200 feet wide road you are showing on the right side. The 30 feet road is in the front.
Press 20, my Lord.
Yes, your objection.
Yes. Yes, yes. But this is another thing, my Lord, which I wanted to show you, Lordship. In fact, I am grateful to my Lordship.
Yes,
Page 20, can you see the bottom, my Lord? 200 feet rasta upare pachiri nirmanara suchana. Now the right side wall that is there, the wall was never there on the right side, but on the north side. But they say 200 feet rasta upare pachiri nirmanara suchana.
No, so this is beyond the 30 feet road.
No, 30 feet is to the left, to the bottom, my Lord.
That bottom only I am asking.
So that is not actually, it's not beyond the road. I have shown you the photographs. There already a 4 feet width gap is there, more than 4 feet. But this map itself, which was issued to me, shows 200-foot road adjacent to my plot. The dimension of my plot is also shown. And interestingly, the land that has been allotted in favor of opposite point of 7 still is described as road. So kindly turn to the record of rights. Kindly turn to the record of rights, my Lord. But the record of right is at page 88 of my brief, my Lord. Page 88. After it was allotted in their favor, still continues to be a road. Page 88 was no kind of thing. This is after mutation. I'll be record of right. But at page 89, Lakshmi kind of thing. Page 89, my Lord.
Which is the plot that you mentioned?
Sir, 2577 by 11250. 2577 by 11250. It is written Patita, Rasta is as road, in middle portion. This is not after this 86 decimal, 0860.
Yes.
So this is after the mutation done by them. After the allotment, still continues to be a road. But prior to that, can you look at page 53 before it was allotted? Page 53. I'm sorry.
Translated the Purva.
Page 53, some agro-based industry.
Page 53 is the record of right.
What is supposed to be rest?
It starts from page 50 minute.
Is
Page 50 minute got answer 12.
Yes.
So kindly see Khata number, the chronic. Sir, English translation is also given at page next adjoining that minute. English translation is there. Khata number is 2339. Plot number is 2577, page 53.
Yes.
It's a Rasta Varand. It's a Wilson Road.
This is a plot number 2577.
2577. Is a prior to allotment and after allotment, both the record of rights, so it's a road. Still it's a road. That portion. Now can you see the allotment that was made, page 48, Annex 11.
Mr. Mukherjee.
Yes, sir.
Take instruction whether they'll break the wall and make it open. Otherwise, you'll land up in a very complicated situation. The conversion, I think, has been done without taking proper permission and proper procedure. Still in 2013 record, is shown as the road.
That I will find out whether land has been converted or not.
And also take your client because only his objection would be limited to this breaking down this wall.
Right.
Because otherwise he doesn't have any right over that land.
No, he cannot have any right. He enjoys the entire land that has been allowed.
If it is a road, you also cannot have any right. So that is right. That is to finally publish the record of rights.
No, this is not the finally published record.
I think
these are the one record of rights.
No, they have not objected. I find they have not objected.
If it is not finally published, there is a need.
No, final public, they are public.
I will find out that with regard to that.
So when can you take the instruction?
What should make grant me 7 days time?
But before that, can I make a request, my lord? But ask any senior lawyer, we're ready to pay the fees, my lord. Our future is depends on that, my building. Anybody can go and check up, my lord. Your lordship have confidence on any person or deputy somebody.
You pay 1 lakh rupee for visit. Senior advocate means you have to pay 1 lakh rupees to visit.
And, if your lordship feels that I should be taxed 1 lakh, well,
I know there is no question. You are offering this thing.
Petitioner.
Big sir, it's not some hospital. Sir, some hospital is the biggest private hospital in Odisha. They have been allotted by government huge amount of land. If your lordship visits that place, your lordship will give such a very good hospital. But I don't have dispute on that.
That's why I'm saying you got to find out a solution.
Exactly.
If the wall is broken, you can open also your OPD, not over that land, but the land adjacent to that. That access is also.
I will get the plan and
Sir, if they open 50% even, that will help.
Why the OPD is being situated?
If they let go a portion of that, so that you'll have some space outside the
wall is demolished and given access to go. So that will also, because I have to go there, approach there.
Not you, your customers.
I think what is broken, I think.
It's a house to stay. I'm used for the time.
Commercial property.
Access to the shops, that side. Other side is.
Because seeing the road get access, he paid the corner also because the corner
that is an issue that he has to take up with the BDA.
Exactly. But his quasi right comes from all this document.
No, right will come once he gets the lease.
No.
As of now, he has no right over the land.
Right is created through allotment, Mr. Mukherjee. Only did formalizes the allotment, nothing else.
It is not as simple as that. Allotment has a lot of conditions laid down.
All right.
All the conditions need to be fulfilled before the lease is granted.
All right.
And now that he has violated the terms of the lease,
We are not entering into the
granted in his favor.
Let them cancel the allotment also. We have no headache. For the time being, he will concern with this controversy.
I will go to your lordship whether it has been converted or not, and what is the plan? Why the OPD has been situated there?
Whether you can
Where a
change it.
hospital is, sorry, Madam?
And whether you can change it and have the parking there and the building somewhere.
Absolutely, absolutely. I will take that instruction and come back to you.
And Mr. Mishra, there is in your document, page 19.
Yes.
It is stated that you have encroached on the government road. So
exactly my
eastern side.
Sir, no.
Eastern side.
Sir, I have encroached 200 feet road. I have encroached 300 feet road.
And my lord, sir, seen a document of
that side.
2018, which shows the he's complaining for the
last line is I have encroached the 200 feet road.
I came into the picture in 2021. So how that I constructed the boundary for the first time?
I've seen the photograph. They have tried to construct it when I objected.
Mr. Mishra, if you have taken a plot, you don't want a boundary wall.
No, sir, boundary on the exterior is open, sir. Every house, if I open a store, like a medicine store,
exactly.
I can put a wall on it.
Mr. Mukherjee tried to find a peaceful resolution of the dispute. What I tentatively what I've gathered from that if you just,
my lord, the person who has paid for 86 decimals of land and for a purpose.
I think this alignment shows that land was not supposed to be given to you. I'm completely, because you are talking about the plan. This is completely outside his alignment.
Sir, that not only that's a residential area. I'm sorry.
I'm sorry.
I'm sorry. I'm sorry.
So, Mr. Don't say residential.
I'm sorry.
You are using for commercial.
You enter converting
I'm sorry.
for the commercial purpose.
So don't say
Residential area. Just find out that is possible or not.
I will take it. I'll come back to you.
Because it is not advisable that you are always in some controversial point in the site. It was such a reputed organization. Find out this little bit of change of mind. Resolve this problem.
Well, if you can really think over it, can be done.
I'll talk to my clients.
And apart from this,
from your lordship, I'll convey it to them. And I will take whatever falls from there, whatever apprehension or whatever, I will put it forth.
Already you consider on the next state whether because I think Mr. Mukherjee is a very positive person.
Yes, Maratha. So I know him from his day of joining here.
But I will request you don't complicate the matter. Right. In this matter,
I want it to resolve.
But because we decide the thing here and they will go to the civil court then for other issues. Just try to have a possible living something and taking advantage of the other things.
Grateful, Marat.
Mr. SP National and Council. Mr. Behra is there. Issued by Mr. Behra and Council for the petitioners. So, they have been shown a lot of documents, including the survey report and real-time photographs to satisfy us regarding the position of land pre and post construction of the wall in front of the along the 200 feet wide road. A little away from the 200 feet wide road. We have also heard Mr. Who is appealing to you for the state now?
I am
Mr. P.K. Mudli on the government of report for the opposite parties number 1, 2, 5 and 6. Mr. D. Mahapatra, counsel, paying for the opposite party number 3, and Mr. Gautam Mukherjee, senior counsel, assisted by Mr. Behra, P. Behra, and counsel for the opposite party number 5. The petitioners have also filed an objection against the survey reports filed by the committee constituted the direction constituted under order dated 3rd March 2023. So according to all these materials will be further considered. So before we just embark on the adjudication of the issue that is permissible under this proceeding, we have requested the party to find out a resolution amicably. So, Mr. Mukherjee, for the purpose, this for a short accommodation. Let the matter come on. Let it be on October last week of mid of October.
But let it be prior to that, Madam. End of next month.
Even more dates. Next month, a lot of holidays also.
Second week, third week.
26th of September. 26th of September.
26th of October.
Yes.
26th. Try to settle the matter. I think it will be good for you.
I do not know whether it's going to be good for me or not, or for my client for that matter. But yes, whatever has fallen from your lordships, I will definitely convey that to your lordship.
Because only that part of the wall you break, and that we can clearly observe.
What your lordship, my difficulty and my predicament, brothers. Once a hospital layout is made and approved by the medical council, various authorities come into play. It will not be easy for me to relocate things. I will not be in a position to do that. So the entire thing will have to be redone all over.
We started with the Medical Council of India studying the site map of the hospitals. That was not
difficulty. I do not know. I'll have to.
Don't be absurd, please, Mr. Mukherjee. We know a little bit of things, how things happens in the ground level. We are just trying to settle up the matter between the parties, and whatever the fate, I do not know for the violations and deviation from the plan. Let it be decided by the appropriate authority. We are not entering into the dispute. It is now not also our business. So only on that thing that we see the alignment is a great difficulty. Your alignment, I do not know how this land has been included in your site. We are not sure. Very unnatural inclusion, I am telling you.
No, it has my requirement of space is such.
And they have the government municipal authority has stated that land, this plot was completely a segregated, separate plot. Later on, it has been given to you. It's not
no, it was not later on given to me. It was given a huge patch of land, about 2 acres, something has been given.
When they found the land belonged to this revenue, the settlement department.
That is 2 acres something, not 86 decimals alone. And it goes to beyond the 30 feet wide road.
That is my impression. It may be wrong also.
So, separate plots together.
Already you come back on 25th, I think 6th.
Sir, 2 o'clock.
The 2 o'clock business doesn't working. It is failing other matters also. How that will take about 3:30.
2 o'clock is let you resolve by your lordship.
Mr. Mukherjee is very stubborn to nowadays. That is why I'm looking at it.
Really convince his client.
No, it's his client. Mr. Mukherjee means not Mr. Mukherjee senior counsel. I'm talking about his client only. Because they have these composite plans and other thing. Because that was, but you try. I think it will be
definitely convey the concern shown by your lordship
Yes.
Whatever has fallen from your lordship, I will
But
definitely.
some documents give certain quasi right in favor of the petitioner. That I am telling you. Wrong or right, whatever. On the basis of those, this projection by the maps and other things and the rules, he has invested and made the shops frontage just this, along the road. That is the thing. That is you just, we say, no, we'll protect your right to use of that land. I'm telling you. We'll protect your right, but not that without that wall. Right to use, you will protect. The vehicle parking and other thing, you cannot say anything. Because already it has been allotted.
Allotted, leased,
everything. That is why it is. Only that you do not obstruct his frontage. Let this person who will be parking the vehicle there also go to his shop and purchase the medicine. That is his entire purpose.
That is the only purpose.
Exactly.
The medicine shop should trade.
Exactly. Okay, let us see. Come. Okay, let us see on 26. Let us see.
May I pray for an urgent copy of your lordship's order?
A copy of this order is supplied to Mr. G. Mukherjee Learned. So Mr. P. Behra and Council of Saving for the opposite party number 7. All right. Which one? Call 85. Interim control is passed. Shall continue. Yes.
Item 85. Item number 85.
So Roy, you just sit for another 10 minutes.
3:30. Refer short adjournment.
85.
Lordship. Any short date.
All right, let the matter be listed on 9th of October 2023. The request of.
At 2 p.m. Lordship.
No, we cannot fix at 2 p.m. You mention on that day.
No.
Sure. There is another matter also. For the matter, 10 minutes in a row and 80. This one is 85. What is the good name, sir?
Escape Pradhan Lordship. Escape Pradhan Lordship.
At the request of Mr. You are there on record.
He is for correspondence. I am for the appellant.
Oh, yes. Sushant Kumar Pradhan.
Yes, I am for the respondent.
At the request of Mr. Sushant Kumar Pradhan and council with the respondent and Mr. M. Kunziel and the National Government has put a case with the applicant.
Well.
Any other matter is there? It's 3. 57. Ms. Das, your matter today with 3:30 you have fixed a matter. Can be some other day.
Tomorrow it may be.
Tomorrow not possible. Second, of your matter.
May I pray, my lord? I would pray, my lord, the matter will be taken up after 10 days. I have prepared a additional affidavit. We are filing it today. But as far as Ms. Das' concern is concerned regarding the display boards, that, my lord, I have had discussed with the Home Department as well as the.
Let it come on 13th September.
Today I am filing two petitions. It may be kept on record. I am serving the copy on the record.
So send to the. Just filing the registry because it is otherwise that will be mislocated.
Let's 10th of
the 13th of September. At the request of MS S. Patnaik and National Government Advocate appearing for the state opposite parties, that the matter be listed on the 13th of September.
Because last chance twice Given so that it may be the.
We are not mentioning even whether they will file or not. So Dr. S. does when considered for the petition and so. Next.
My additional affidavit is there on record, my lord. I've already filed an additional affidavit on 29th of.
That is already on record.
That is already on record.
It is even right now we will pass the order. Adjournment was been carried 85. All the 87 let us see.
87. Sir.
I want to petitioner matters. Petitioner completed matters that is master in dental surgery in 2000.
Who is appearing to the state?
I am the state. OPSC council is there.
I am there. Okay.
Right.
I'm here, but he has deleted my clients. So I don't know.
The private one opposite at number 4 my lord.
He has deleted my client's name.
Last category has made a submission to that
I have selected and I have secured more marks than him. He considered to that effect and delete.
And one opposite at number 4 my lord. That is the course. Yes, of the petitioner my lords. The petitioner my lords has completed master in dental surgery in 2015. And he had completed senior residency in Burla for the period from 2014 to 15 to 2016. Then senior residency in SUBHASIS Dental College in 2016 to 2019. And as my lord said, in 2015 to 2018, he had 3 years experience, my lords. And kindly just to annexure 7 my lords.
Of writ petition. Of writ petition or writ appeal?
Writ appeal, my lords.
But a writ appeal, there are only 4 annexures.
Yes, that is the page, my lords. Page 55 of the writ, my lords. And the advertisement was made by the Orissa Public Service Commission. Page 55, my lords. The advertisement was made by the Orissa Public Service Commission for, my lords, that is oral medicine and radiology. 2 unusual posts are there, my lords. And in the page 56, my lords, there is educational qualification and experience have been prescribed, my lords. Page 56, my lords. And in clause 4, it was specifically prescribed the selection of the candidate for recruitment to the post will be made on the basis of the Odisha Medical Education Service, Method of Recruitment and Conditions of 2013. Selection to the post of assistant professor shall be made by way of direct recruitment to the commission from amongst the candidates having PG degree in the concerned specialty with 3 years experience. With 3 years experience as a tutor or senior resident from any medical institution recognized by the MCI. My lords, I have completed 1 year residency in Burla and a 2 year residency complete. My lords, I have completed 2 residency in the SC Medical College. I have 3 years experience as an advertisement, my lords. And I have applied and pursuant my application, my lords, a shortlisted candidate for my lords. Then my lords, a written examination was made, and in written examination I completed, my lords, and in they have verified the service particulars, my lord, that is, they verified the certificate, and they have rejected my lords, and by the annexure page, by the page 69, that no required period of tutor of senior residency, which was challenged before the Honorable Single Judge, my lords. The Honorable Single Judge, my lords, at page number 106, pointed that the senior residency is a course. But there is no senior residency, it is not a course, my lords. There is no degree certificate will obtain.
You also proceed. Don't harp on this point.
Yeah. Senior certificate, that is my point, is, my lord, that is not a course. There is an experience. Yes. There is a 3 years experience is required, my lords. Yes. And I have completed 1 year experience at Burla and 2 years experience at consecutively I have 3 years experience, my lords. I don't know.
Counter affidavit filed by this.
No, that at the stage of admission, the case was disposed of, my lords. No.
What is the judgment of the London Single Judge?
That is, my lords, at page 100, my lords. At the stage of admission, the case was page 100. Yes. 100 ballots, that is, turn to ballots, that is page 105 of the deep ballots. That is last paragraph. The petitioner while prosecuting such senior residency at Bhimsar for the period from 3/9/2015 to 14/9/2016, he participated in the selection process initiated by the SCB Dental College and Hospital on 30/7/2016. The petitioner being selected took admission to prosecute senior residency at SCB Medical College and Hospital, Cuttack, in the discipline of oral medicine and radiology, and he had completed the course by undergoing the entire 3 years of senior residency from 2015, from 15/9/2016 to 15/9/2019. Therefore, as per the considered view of this court, the senior residency undertaken by the petitioner at Bhimsar for the period from 3/9/2015 to 14/9/2016 cannot be taken into consideration to calculate the required period of 3 years as provided in para 4 of the advertisement. Turn to my lords, the my lords, I have turned to paragraph 4 of the advertisement, my lords. Paragraph 4 of the advertisement never says, that is page 56, my lords. Paragraph 4 of the advertisement never says that in one medical institution. Paragraph 3 provides that in any medical institution, 3 years experience is required.
Who is appealing for the state in this matter?
I am appealing for the state. This is the
You are for the commission.
Yes, just a minute. Yes. Let's kindly see. Paragraph 7.1. The petitioner, that is page 105. The petitioner, while prosecuting such senior residency, let's say for a moment ignore that prosecuting, that what may be undergoing training or whatever that may be. At Bhimsar for the period from 3/9/15 to 14/9/16, he participated in the selection process initiated by SCB Dental College and Hospital on 30/7/2016. The petitioner, on being selected, took admission to prosecute senior residency at SCB Medical College and Hospital, Cuttack, in the discipline of oral medicine and radiology, and he completed the course by undertaking the entire 3 years, 15/9/16 to 15/9/16. Then let's kindly come to this.
Just before that, explain before us.
Yes.
What is the residency, senior residency? Is it
senior residency? That is the training course. That is undergoing the experience. That is experience.
It is an engagement job.
It is not a job. That is a requirement to undergo the that training course.
But it is a job on the payment of that the government pays them, they serve the hospital.
That is right. I am not on that point. I am on the point. Kindly come to page 35.
Yes.
35. That's it. Kindly see annexure 3. Page 35. This is to certify that Dr. Srimay Mahapatra has worked as senior resident of Dentistry Department, Bhimsar, Kurla, with effect from 3/9/15 to 14/9/16. Then let's kindly turn to next page, page 36.
Yes.
Then this is a document dated 16/9/19.
Okay.
Let's see, got it?
Yes.
What I mean to say, then kindly see the advertisement. That is what is meant by the Honorable Single Judge. Like, kindly see page 55.
Yes.
Your Lordship will find online applications are invited from the prospective candidates through the pro forma application to be made available on website from 12/10/18 till 12/11/18. That means last date is 12/11/18. So that document has not gone by that time. It is not produced. Now it is annexed to this document in the writ petition. Obviously, that document could not have been made available to him and he has not submitted.
What was the last date?
Last date is 12/11/18.
That is what is meant in that order. No, not expressly so many words it is explained, but it is meant that for that period, the document obtained and shown to your lordship 16/9/2019, whether it is submitted, could not have submitted this. This is a document of 2019.
Yes, but that purpose, my lords, there is advertisement advertisement at page 55, my lords.
55.
The top, my lords. That is only, my lord, the online applications are invited from the prospective candidates through the pro forma application to be made available from so and so date and so and date. And then, my lords, clause 9 of that advertisement, my lords. Clause 9 at page 60, my lords.
Yes.
When the documents will be verified, my lords. Clarification of the documents and print out hard copy of the online application to be produced for the verification and then when asked for.
Yes, that is whatever you apply, that will be verified.
And when the place, and that is, my lords, that has been verified in 2021, my lords. That is, my lords, at page.
But whatever documents are filed, those hard copies are verified. More than whenever you obtain, supposing you have not obtained the dental surgeon, then can that document be one is by that time?
Because
that is the main lord, because it is just changing the rule of the game.
But because
whoever will come in the way, by that time obtaining, will say that I am also eligible for this job.
You have not stated specifically in the advertisement that experience by the date of advertisement.
No, that is obvious. That is obvious.
That is why he's taking it.
Always in the advertisement. That is right.
Just a minute. Is it your case that on 12/11/2018 he did not have completed the requisite experience years?
He has not given that document. I am saying
that is a separate issue. Let separately consider this.
That your lordship
certificates given by the hospital authorities or the college authorities. Do you find that before 12/11/2018 he did not complete the experience?
That document is not there before us because they are not submitted.
Showing that the document will be scrutinized. Where is that?
Clause 9 of the advertisement, it page 60, my lords.
9 and 10.
Clause 16.
Yes.
Certificates of documents and printout public hard copy of online application form to be produced for verification as and when asked for.
Yes, online. Whatever you submitted online, that is to be hard copies to be submitted.
There is the clause 9.
Yes.
Latest medical recognition certificate. This is not clause 9.
Page 60.
Page 60 minutes.
Bottom.
That is clause 9(3), Roman 3.
3, yes.
3. And that is 4, 5, it will come 5. Roman 5, it will come. Within that. Certificate from competent authority regarding the prescribed experience.
Yes.
And on the and heading is what? The online documents, whatever you submitted, that document hard copies to be submitted.
Already submitted.
Already submitted. Online. Because otherwise it will be frustrating the advertisement itself. Whoever will be coming, then also supposing considering for the sake of argument, supposing somebody will say, now I have come with an application that this is my hard copy of the application. I have passed recently, just 2 months before, BDS course and my accident and considered.
15/11/2018, my lords, I have 3 years experience. So I have 3 years experience. 1 year, my lords, at a Bulla and 2 years at a Seaman.
They are not objecting to that. They said he did not file these documents.
Because online applications were invited. And online.
Just you read the 9. This page
9. Certificate of documents and printout. Certificates, public documents and printout. Public hard copy of online application from to be produced for verification as and when asked for. When they are verified, they are verified in 2021. And as of 2021.
Page 61, note 2. Here I am referring for open number 6, my power is accepted. There is a note 2.
Yes.
Yes. 61.
Certificate, documents and printout hard copy of online application form And from this, it is not obvious that the certificates document should have been filed along with the application form.
Yes.
From this, it is apparent that certificate documents and print out hard copy of online application form.
Online application, the advertisement was for online application.
Yes, wait, both of you we can't understand.
Within the last date fixed for submission of online application form.
While
So that cut-off date is the last
while
date of
filling
the.
up, what is that? Which one?
Note two. Note two.
Last. Note two actually is very clear.
That is for establishment.
What one? Degree certificates?
All the certificates, for all the certificates, you can find it from.
Yes.
This clinches the fact.
Experience certificate and discharge certificate.
It is a common sense.
No, common sense, but if he finds a way, he will challenge. This makes it clear.
Certificate.
Mr. Panda, this one.
That is my clause 2.
Not two. Read it slowly.
Degree certificate, caste certificate, Korea test pass certificate, experience certificate, service certificate, and discharge certificate of ex-serviceman. Ex-serviceman.
Service that is the discharge order certificate.
Issued by the competent authority within the last date fixed for submission of the online application form.
Yes. Whatever the document there. So this is the all documents you are required and that should be issued before the last day. And Mr. Mohanty has pointed out that you documents, those are you have submitted later on and were issued after the last date. Last date was 12/11/2018.
Exactly. That is.
So you have no case.
That is for ex-serviceman. That is for
don't ask me. Only is for the purpose of discharge
Discharge certificate. Service certificate and discharge certificate.
Okay. Heard, Mr.
For OP number 4 minutes that I find my power that may be accepted.
Wording may not have been
The data also got appointed and.
Heard Mr. D.K. Panda, learned counsel, appearing to the appellant. And also Mr. M.K. Kuntia, learned counsel. Along election government advocate, appearing to the opposite party number 1, and Mr. Pradipto Kumar Mohanty, learned senior counsel, who is this? Mr. Mohanty. I'll tell your name. Assisted by MS. Your name is? I forgot again.
Name
K.T. Mudali.
K.T. Mudali, learned counsel for the opposite party number 2. You are appearing for whom?
OP4 man.
And Mr. S.K. Tripathi, learned counsel, appearing for the opposite party number 4. There is no representation on the opposite party number 3. Was deleted by the order dated 14/7/2023. By means of this intercourt appeal,
just 1 minute, my lord. 1 minute, my lord. That is note 2. That is only for my lord. My specific argument, my lord, that is for only ex-serviceman.
All that will record it. Yes, we'll record it. All right.
That is my lord.
Means of the just now take your seat. Your rule is over. This intercourt appeal. The order dated 4th July 2023, delivered in WPC number 20275 of 2023. Because the learned single judge has been challenged. So, by the said order dated 4th July 2023, and its single judge has observed that the petitioner on being selected to admission to prosecute senior residentship at SCB Medical College and Hospital and Kotak in the discipline of oral medicine and radiology, and he completed the course by undergoing the entire 3 years senior residency from 15/9/2016 to 15/9/2019. Therefore, as per the considered view of the court, the senior residency undertaken by the petitioner at Bimshire for the period from 3/9/2015 to 4/9/2016 cannot be taken into considerations to calculate the requirements. The required 3 years is provided in para 4 of the advertisement. Therefore, this court doesn't find therefore the legislature did not find any illegality or irregularity with the impugned rejection of the candidature on the ground indicated there. Mr. Pandal and counsel appearing to the appellant has clearly submitted that the senior residency is not a course, but it is an engagement. And the observation of the civil judge is entirely unsustainable. According to him, according to the eligibility criteria, the appellant has fulfilled all the eligibility criteria have been fulfilled by the appellant. But despite that, his candidature has been rejected. Mr. P.K. Mohantil and his senior counsel appearing for the opposite party number 2 has clearly made a statement that candidature was selected as the appellant did not submitted the experience certificate which was issued before the last date of submission of the application, i.e. 12th November 2018. Mr. Mohanty, learned counsel, has referred particularly the experience certificate dated 16/9/2019 issued by the SCB Dental College and Hospital, Cuttack, Annexure 3 to the repetition. The said certificate has been undoubtedly issued after the last date of submitting the application online, i.e. 12th November 2018. Stop. Therefore, according to Mr. Mohanty, learned counsel, his senior resident his tenure as senior resident in the Department of Oral Medicine and Radiology at SCB Dental College and Hospital, Cuttack from 15/9/2016 to 8/11/2018 and 18/11/2018 to 5/9/2019 could not be taken into consideration. Though the according to the said experience certificate, petitioner had completed 2 years of senior residentship before the first date of filing the application, i.e. 12/11/2018. So, in this regard, Mr. What is that, the advertisement, Mr. Muduli?
Page 61. The last you can find it for the
regard.
61, man. Page 61.
In this regard, reference has been made both by Mr. Mohanty and Mr. M.K. Khanti, Council, Additional Government Advocate appearing for the visit party number 1, to the note number 2 of the advertisement. For purpose of reference, the note number 2 is extracted. So, quote, note number 2. Degree certificate, caste certificate, ORIA test certificate, experience certificate, service certificates, and discharge certificate of ex-servicemen must have been issued by the competent authority within the last date fixed for submission of online application form. According to the counsel appearing for the opposite parties number 1 and 2, the experience certificate issued by the SCB Dental Medical College was much prior to the last date, and as such, that certificate has not been considered by the competent authority. But in this, on this, but Mr. Panda, learned counsel, has submitted that this note is only applicable for the ex-servicemen, not for the other candidates. So, we are unable to accept the contention of Mr. Panda. The said note number 2 was applicable for all the candidates. So, where the reference of the ex-serviceman is concerned, it has been made only for the discharge certificate, not for all other certificates. As such, in absence of proof of completion of 3 years residentship as claimed by the appellant, rejection of the candidature cannot be held illegal. As such, we stop. But we do not affirm the observation of the learned single judge that the residence certificate is a medical course. It is a job, and it creates work experience in the hospital for the medical, for the persons who have passed the MBBS/BDS. Therefore, even though learned single judge has rejected the petition of the appellant on that ground, but we cannot affirm the said observation. Stop. However, on the ground as aforesaid, this appeal also cannot be allowed. As a result, we do not find any infirmity in the decision of the opposite party number 2 in rejecting the candidature of the appellant. Consequently, the appeal fails and the same is dismissed. There shall be no arrest to cost. Next matter.
Item 56.
May it please your lordships. On the last occasion, they have brought to the notice of the government made in para 5, page 3 of the affidavit that one of the office bearers died in April 2020 and the application which was submitted on 22nd of April 2021, I have not disclosed it. Just a minute. After
my learning senior submitted this, that person was alive. I have sought for instruction whether this affidavit is correct or
Who are you to decide it?
No. I have sought for instruction from the they have mentioned that the person died in the year April 2020. Therefore, my learning senior submitted that during that application he was not died. That's why I have sought a clarification from the department.
What department will clarify? They have filed the death certificate.
Yes.
Thereafter they have filed it. And there,
immediately after the counter,
in reply to the affidavit matter, I have sent to the department whether yes, madam. So that has not come till that matter. Some time is required.
I will take up the matter on 5th of September and no chance will be given on 5th of September.
Yes.
Heard Mr. Siddharth Royal and senior counsel in part by Mr. K.
May I have a...
Enough is enough, Mr. Pari.
No, we are not taking time.
An authority competent.
Not asking for time. You're not asking for time.
You are asking for time.
I am asking for time for getting instruction. Can it be another some few days?
No, 1/5 is the outer limit. It is an age of technology. You can get it by tomorrow also.
We will try to get it as quick as possible, my lord.
That is, we are keeping on the next week, 5th of September. All right. Yesterday, Mr. K. Saul and counsel. But at this juncture, Sorry.
There is a holiday matter. That's why I am.
So what holiday?
Saturday, Sunday.
Today is not holiday.
No, Saturday, Sunday.
Tomorrow is also not holiday.
Monday is there. Monday is there.
One day, my lord. It could not be. They are, as per today morning,
What do you say?
Today morning I have told with the...
Mr. Pari, what do you say? They will say the medical certificate is wrong.
No, they have to sort for the field inquiry report, my lord.
What field inquiry report?
The personnel who went...
Who asked for the field inquiry report? You have taken a decision.
Yes.
The posterior field inquiry report doesn't have any implication.
Or two days, man.
No, man.
Every time they are
Affidavit. When did you serve the affidavit on that?
Long back, my lord. Long back.
I have.
Did they serve it today?
No, August.
So this is 31st.
That day also, I have sent the letter, madam.
Very good.
That day,
And they have, to my information, they have come, they have inquired in a jeep, they came, inquired from the medical and went back. They have also inquired from the medical. That is my information.
No, that nothing will say.
Let the matter be listed on 5th September 2023. So, and the request of Mr. B.S. Mr. P.
Madam, can it be on 11th?
No, 5th, no. We are not.
6, 7 is a holiday. 8.
No.
8th is a Friday, we cannot fix any matter.
No, 5th. 5th, my lord.
My lord, it is enough. The council cannot fix the date. Which date will be fixed?
No council
What is the prerogative to decide?
The party, no council can fix it. All right.
The court will decide what today. We know. I am saying the date is no.
Mr. Pari, that you have received their affidavit on 22nd of August.
Yes.
We are on now 31st of August. We are extending another 5 days for you. It is not that the central government officer
What I
doesn't
am playing,
work.
my lord, we don't want to adjust, we complete the pleadings and complete the pleading only to take some little instruction. It is because it's 6 and 7 day holiday, it is the 8th or 11th. They say limited prayer. I have.
All right, on 8th. I see. It is a special matter on 8th.
Time may be fixed, manners. Can it be?
8th at 10:30.
10:30.
The first matter.
Yes.
I'll just
made absolutely clear, no accommodation on that day will be entertained.
10:30.
No other matter now.
I'll just, before I leave my lords, the medical certificate itself, so.
Sir, this is, we have fixed on 8th as the first item of the day, 10:30.
Much obliged. Much obliged.
So I have to,
item 60 for my lord, interim order of maintenance.
41, give a date, 41.
I understand. Can it be fifth or fourth?
Which matter?
Well, item number 21. I will take my chance.
No, the date. Just in this matter, item 20, make it on 5th.
That's perfect. Let it come on 5th or 6th.
All right.
Item 60.
The item number is 41.
Item number.
Just to see the lawyers now. And part in part, for conclusion, there is a matter on 5th September 2021. Along with analogous matter, this for 40.
I'm not, I can see it. Let's say fix up 14 September. Items 55. 42.
64. In which case, all right.
Item 55. Item 55. Let it be listed on 12th.
Well, no, it will be listed on.
Can I see? Item number 73.
of September.
Item 19. It's a series of writ appeals, your lordship. There's a certain defect, your lordship, but because the file is not sent back to the registry.
I'm actually working on that case, item 19. Also fix up another date so that we can remove the defects in the meantime.
All right. Remove the October month of
because the files are here, so the office is not in a position.
9th of October 2023. All right.
Item 69, your lordship. Item 69, interim order to continue, let the 9th of October. Interim order to continue.
Interim order shall come.
69, interim order till date not, so it may be extended.
69.
Yes, your lordship.
I love the matter will listed on 9th of October. Interim order.
Item number 36. So if you are not taken up next week.
Cannot be. Just see that when we list the matter, we cannot take up the matter. Granting a time, 25th of September, this matter will come.
Item 71 and 72 that we listed today, and for this 200 purpose, the girls have been rescued. So they will dispose of, otherwise we go to some other date for.
All right.
73, 71 and 72.
Disclose matter.
Just 73 habeas corpus file. 71 and
72.
73 not restored.
Just to give
the instructions, it can be disposed.
give copies of the.
Yes, I give the
73 not restored. Habeas corpus file.
From this is what,
73, my lord.
73 is the give a date, 5th of September. 5th of September.
Item 45.
Since 2 years ago, the RCP is not able to sign acceptance is allowed. They will be the period.
22nd of September. 22nd of September.
Item 43, man. Item 43. The interim order is still today.
List on 9th of October.
May I be pardoned, my lord?
Till the next date.
May I be pardoned, my lord?
Well, item 63, your lordships had called out the matter at 12:30. The respondent was not there. But the content matters tomorrow. I'll seek an adjournment before the learned senior judge. Your lordship may take this up next week if convenient to your lordships.
The data.
Lordship,
25th of September.
Opposite party in this case, but in spite of our lordship's order, they have not sought copy, my lord. The applicant has not sought copy.
Served copy first. I will defer to
Lordship, item 69, your lordship. Just item, if I understood correct. My lord, all I'm praying, we have appeared for opposite party number 8. They are enjoying the interim order, my lord, an early date, your lordships, because our public hearing by virtue of your lordship's interim order has been kept at abeyance. And they are proceeding with their public hearing.
All of it is come on 27th September.
Yeah, let's see, item 53, let's see. Let's see, it's an urgent matter that stay order is operating against us, my lord. Kindly taking it any day, next week, my lord.
Next week is not possible, 22nd of September it will come.
Lordship, item number, your lordship, item number 27, your lordship, item number 27.
Yes.
May be taken up, next week. Your lordship,
Always, it will be done celebrate. 2nd September.
And the item,
recent that you today item 18.
Given 25th September.
I got
25th September.
I got 25.
25th of September.
I 29.
25, my
But item 20, objection letter.
2nd September.
My lord, item 10, my lord. This is a bail matter. I have filed an interim application. I have permitted to withdraw my interim application so that it can be hard finally, my lord.
Only 2nd September it will come.
item 25, my lord.
2nd September, you filed it 2nd September. Memo of withdrawal.
Yes, sir.
Filed on 2nd September.
Okay.
My lord, item
Item number 22 and 51, my lordship, both are identical matters. My lordship, can you fix up a date?
9th of October.
my lord, 25 item, my lord.
Both the matters.
My lord, item 25.
Yes. Date will be given.
My lord, in the third week, madam.
In 22nd September.
For orders item number 1.
Yes, item 1 is relates to a writ appeal before your lordships, my lords. This matter has been transferred to me, my lords, because one of the conducting counsel has been elevated to a judge, my lords. My lord, the basic question that arises out here is, my lord.
You appears for the appellant now, you are appearing, my lord.
Yes, my lord, I am appearing for a court.
Appellant.
The appellant.
Where is Mr. Pari?
Because this will take, I mean, it will take some time. The question is very simple, my lords. VRS having been once accepted, can he still pay for regularization, my lords?
I think you have to take notice because my brother Justice Rao points out that Mr. P.K. Pari is not the counsel for the respondent.
No, lords.
You take steps.
No, lords, he'll take steps. Yes, lords.
You take hard Mr. Milan Kanangu and his senior counsel. Assisted by, what is his name?
Assisted by Ashish Mishra.
Mr. Ashish Mishra for the appellant. His appeal has been restored to file by the order dated 5/5/2023. So, but it has been, there is no representation from the respondents. In view thereof, we direct the appellant to take steps on the respondents number 1 and 2. One, 2, and 3, because we don't know 1, 2, and 3 by registered postal baby. No, notice is made returnable on 19th of October 2023. So, in the order dated 21/8/2023, name of Mr. P.K. Pari, Planet Deputy Solicitor General, has been reflected as respondent number 3. Now just go out. I think Mr. Pari can appear for the railways also.
I think so, my lords.
So the steps on 1 and 2. Yes, Mr. P.K. Pari, Deputy Solicitor General, has entered in the appearance for the opposite party number 3. No? Then the returnable date answer is a date.
There is a contempt case.
There's also
Yes, I'm appealing for the.
There's also a contempt application in view of the fact that this writ appeal has been preferred, my lords. We have not acted on that order, my lords. The writ appeal has.
Lordship, that is 1753/23. Lordship, in that contempt case, only notice has been issued. Lordship, that was filed after the dismissal of the writ appeal. That was filed, but thereafter this has been restored, and the matter, the writ appeal has been currently listed. So therefore, that may be transferred to the assigned bench, Your Lordship.
Which one?
The contempt case that isn't listed, Your Lordship. Contempt case 1753/23.
No, let it lie along with this, my lords, because this is being heard by a special bench. Lordships will decide. If your lordships decide,
we will try to just. It is not there because it was taken by judicial order. Purpose is known to all of us.
No.
So we will not take right at this point. Next day, you just renew your prayer. Let everybody come and decide it.
I mean, format item 83. Item 83 may be taken up on 2nd of August.